All right, good morning, counsel. Back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Ms. Chapman, Mr. Cochran, Mr. Bailey, people represented by Ms. Clark and Mr. Darden. The jury is not present. Counsel, do we have counsel for Mr. Kardashian?
Your Honor.
All right. Good morning, counsel. Your name for the record, please.
Janet Levine, appearing on behalf of Robert Kardashian, Your Honor.
All right, counsel, we've had the opportunity to converse in chambers between yourself, myself, and Mr. Darden. My understanding is our agreement is that Mr. Darden will make available to you the general areas of inquiry, or the proposed general areas of inquiry, by the close of business today, and that you will provide me your brief on the issues by the close of business April 5.
That's correct, Your Honor. I understand also Mr. Darden will be providing me with a copy of a videotape as well as some still pictures.
That's correct, Your Honor, but we'll have to charge you for the videotape.
As long as it's not too expensive, that's fine, Your Honor.
All right.
Thank you.
All right, thank you, counsel. All right, anything else we need to put on the record, counsel? All right, let's have the jurors join us, please. Let the record reflect we've now been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, Mr. Darden, you may call your next witness.
Thank you, Your Honor. Good morning, ladies and gentlemen. Your Honor, the people call Susan Silva.
All right, Ms. Silva, come forward, please.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. And if please have a seat in the witness stand and state spell your first and last names for the record.
Susan Silva, S-I-L, V as in Victor, A. Good morning.
Ms. Silva, who are you employed by?
West Tech Security Incorporated.
Okay, and what type of business is West Tech Security in?
We are in the business of installing, monitoring, providing service, and patrolling alarm systems.
Okay. And what is your job title with West Tech Security?
I'm Director of Administration.
Okay. And are you an expert on West Tech installed security systems?
I wouldn't consider myself an expert, but I'm knowledgeable about them.
Okay. And how long have you worked for West Tech?
6 years.
Okay. And what did you do prior to that?
I worked for API Alarm Systems for approximately 7 years.
Have you visited the house at 360 North Rockingham?
Yes, I have.
And does that house, the defendant's house, have a West Tech installed security system?
Yes, it does.
Okay. And have you searched the records at West Tech to determine the nature and type of security system installed at the defendant's home on June 12 and 13, 1994?
Yes, I have.
Okay. And can you describe that system for us, please?
At the current time in June of 1994, he had a system which entailed a perimeter alarm system, which means that there were contacts on many of the doors around the exterior of the house. As well, he had one interior beam in the front foyer.
Okay, so you say there were contacts on many of the doors,
That is correct.
many of the exterior doors?
Yes.
And the beam you just described, where was that beam?
The beam was in the front foyer. As you're coming in, if you were to walk in, it was directly, as you're walking in the door, it would be directly to your left.
And assuming the system was on or activated at the time, what would happen if you interrupted that beam?
The system would be activated and an alarm signal would be sent into West Tech if that beam was a part of the system and activated.
Now, was there a main computer somewhere located in 360 North Rockingham?
Yes, the main computer or box or guts, as you would call it, the processing unit, was in his library.
We'd like to mark it people's next in order, 156, I believe.
156.
Are you familiar with the term entry panel?
Yes, I am.
And what does that term mean?
An entry panel is a panel that would be immediately inside an area to turn the system on or off.
Would that be a keypad?
Yes, it would be.
Okay. And the owner, or in this case, the defendant, could punch in a security code to activate or deactivate the alarm system?
That is correct.
Ms. Silva, if you will you step down from the witness stand, step over to the board marked People's 156. There's a pointer behind you hanging from the witness stand. How many entry panels or keypads are there at 360 North Rockingham?
For the lower portion of the alarm system, he had a total of 4. There were 4 keypads that he could turn it on and off. There are 2 exterior, which are different types of panels. One was installed outside of the front entrance in the foyer, and the other was right outside the garage, in the main garage area. He also had 2 keypads from the inside that were one inside the front entryway and the other right outside of the maid's room.
Now, to use the entry pad located in the garage, one would have to be inside the garage, is that correct?
That is correct.
And with regard to the keypads inside the laundry room and the interior entrance way to the house, you'd have to be inside the house or inside the laundry room to activate those.
That is correct.
But there is one keypad at the exterior front door, is that right?
Yes, there is.
Just outside the front door?
Yes, there is.
And the keypads you just described, do they all require a security code to activate or deactivate the alarm system?
Yes, they do.
Now, are there also security sensors?
Yes, there are sensors on many of the doors.
Okay. Before I ask you where they are, let me ask you this. Directing your attention to the maid's quarters and Kaylin's room in the lower portion of the diagram there, are there any security sensors or entry panels located in any of those rooms?
No, there is. We at one time believed that there was some sort of a sensor, but when the day that I was out at the property, the sensor was not connected to the stair room or the rooms from Cato's room to the billiard room. But there is no on and off keypad of any type to deactivate the alarm system with the same type of keypads that are installed at any one of these 4 locations.
Okay. So in other words, then there are no security sensors anywhere from the office here to the maid's room.
That's correct.
Could you describe for us each and every sensor or security sensor that is located inside the house, please?
If you were to begin at the front door, there is a door contact that is, most of them are, you're not able to see them. They're recessed in the door itself, on the top, on the side, so that it's not really visible. But there's one at the front door, and you go back to the patio doors over on this side. There is one on the door there, one on the door here, another door contact as well here.
Okay, now those would be the French doors leading out to the pool, is that right?
Correct. They're very large, probably 10 or 14 foot tall French doors.
Okay.
There's also French doors on this side. There was one here. There's one here. There's a small door going out to the pool area as well that there's a sensor. Finally, over here at the maid's room going outside on the side yard, there's a sensor, and one sensor going out to the garage.
Is there any exterior door to the house that is not that does not have a sensor attached to it or covered by it?
Well, when we looked at it, it was very difficult because at the top of many of these large French doors were some deadbolts. So at the time, and because it's so tall and we didn't want to get a ladder and unlock them, we were unable to tell whether there was a contact or not on those particular doors. So my estimation is that the one was a standard closed door at all time because it also had a sliding bar in the bottom, and the other was a door that would be open and closed at all times.
You just mentioned that you saw some deadbolts.
Yes.
Where did you see deadbolts?
There's deadbolts, large deadbolts up at the top of the windows at this side, and they're very high up, probably 12 of them, and at the very top of the windows itself.
Okay, and you're indicating for the record the living room and the family room?
Correct. Living room, family room. There also was a deadbolt at the maid's room. Open that door.
Okay, and so that the record is clear, there's a room here at the bottom left-hand portion of the diagram that is labeled maid, is that correct?
Yes, there is.
Okay. And that is adjacent to the laundry room?
That is correct.
Okay. And you can access that room from inside the house, is that correct?
Yes, you would walk through the breakfast area or through the garage.
Okay. And you can also access that room from outside the house?
That is correct.
Okay. And this maid's room is distinguished from the other maid's room, which is at the opposite end of the diagram.
Yes, I'm sorry, I didn't see that this one was also labeled as maid's room. Yes, it would be the maid's room that was inside the interior of the house.
Thank you. Okay, you were telling us that you saw deadbolts at the living room French doors and at the family room French doors?
Correct.
Okay. And where else did you see deadbolts?
There was another deadbolt here at the maid's, outside of the maid's room from the interior of the house going to the exterior, the maid's room closest to the garage.
Now, at one point, you pointed out a sensor located at a rear door leading out to the patio, rear patio. Is that right?
Yes.
Okay. And we've indicated on the diagram 40 seconds. Is that right?
Yes, that's a special door right at the, not identical to the large French doors. It's a small door right on the side.
Now, what did you mean or intend to convey when you had the 40 seconds placed there or indicated there?
That was the one door on the back side of the house that if someone was at the pool area and the alarm system was set, they would be able to enter this door and have a ringing sound and be able to go to one of the keypads and disarm it. All the other doors are on immediate sensors, which means if they were to come in the front side, they'd have to de-arm the system from the outside key panel and also the garage key panel, or else the system goes immediately into an alarm. On many systems that don't have these exterior panels, you have entry exits to give you the time to bring your groceries in, put them on the counter, and go turn your alarm system off or let the kids go or whatever. In this particular system, he had to disarm it from the outside before he came in, or else you'd have an immediate alarm system. I'm sorry, an alarm activation. This particular door, he had 40 seconds to, if indeed the alarm system was set, 40 seconds to go to any one of these keypads and turn it off. It would not send an alarm signal.
And what if the glass was broken or a window was broken? Would that activate the alarm?
No, he did not have any glass breaks on his system. So there was not that type of protection. They would have physically had to have moved or caused the two magnets, which is what a contact is, to move and cause an alarm.
Okay. You have one moment, John. West Tech advised or signaled somehow each and every time that the alarm is activated?
Objection vague.
Or you can answer the question.
If you could, please define indicated, activated.
Okay, well, let's say that Mr. Simpson was to turn on the alarm. Okay? With me so far? If he turned the alarm on, would West Tech somehow be notified? Would there be some signal or something sent to West Tech indicating that the alarm at Mr. Simpson's house is now on?
No, this particular alarm system is not supervised, which means we do not supervise or have specific times that he would set the alarm or turn the system on or off. It's basically at his own discretion.
Under what circumstances, if any, could West Tech be notified that the system has been activated or deactivated?
It would be an intrusion, which means that he has physically set the system, and not necessarily him, but let's say a burglar breaks one of these door contacts or goes in an area and is not able to deactivate the alarm system in the appropriate time period. At that time, we would receive a signal. So it's more of a reactive than a proactive system.
Okay. And have you searched the records at West Tech?
Yes, I have.
Okay. And was West Tech signaled that the system had been broken, or that the security of Mr. Simpson's home had been broken on June 12, 1994?
There were no signals.
Now, does West Tech also perform maintenance on security systems?
Yes, we do.
And if you recall, when was the last time that West Tech performed any maintenance on the defendant's security system?
I don't recall.
Okay. If you recall, were there any complaints during June 1994 that the system was not working properly?
I don't recall any.
Thank you. That's all.
Oh, thank you. All right, do we need the board at this point? Ms. Chapman, do you need the board? Ms. Silva, why don't you take witness stand again, please? Ms. Chapman, do you need the board for your cross-examination?
I don't think so.
All right, thank you, gentlemen. Ms. Chapman.
Good morning, Ms. Silva.
Good morning, Counsel.
Good morning, ladies and gentlemen. It's your indication, Ms. Silva, that there is no signal sent to West Tech when the alarm is set by the resident. Is that correct?
That's correct.
And there would be no record anywhere that you're aware of the alarm being set. Is that right?
That's correct.
Okay. Now, to set the alarm, you would have to enter a code. Is that right?
Yes.
And you would have to enter a code at a pad at either the front door or at the garage. Is that right?
Yes.
Okay. Now, if the alarm was set and someone left through the kitchen door, the alarm would go off. Is that right?
Yes.
With respect to the alarms on the family room doors, if the alarm had previously been set and people were to come through any of those family room doors, would the alarm automatically go off at that point?
If you're any of the doors with the exception of the one entry-exit door, the alarm would automatically go off.
Okay, so the alarm that you indicated that had the 40-second delay, if someone came through that door, is it your testimony that the alarm would not go off? There would be a beeping sound allowing someone to go turn off the alarm. Is that right?
Correct.
If the alarm had not been set and someone were to enter the home, nothing would happen as far as the alarm system is concerned there at the residence and also at West Tech Center. Is that right?
Correct, unless someone at the premises either hit an emergency button or something like that. But if the system was not set and somebody walked in the door, no, we would not receive any signals at all.
Okay. If, hypothetically, Mr. Simpson and a friend were leaving on the 12th to go get a hamburger, and they went out the kitchen door, and the alarm had previously been set, the alarm would then be activated at that point. Is that correct?
If the alarm had been set from the interior or from the exterior?
From anywhere. If the alarm had been set, because you indicated it has to be at one of those two keypads, correct?
Right.
Okay, so if the alarm had been set at either of those keypads and Mr. Simpson and a friend went to get a hamburger through the kitchen door, the alarm would then go off, isn't that correct?
Yes. With that type of system, what you really need, and that's why he has the outside panels, is you don't set the system to go out through the panels on the interior of the house, because it'll set the system off. What you would do is set it from either outside the front foyer or outside in the garage.
Right, thank you. I have nothing further.
Mr. Darden, any redirect?
Are there any other keypads in the house that you have mentioned already?
There are keypads upstairs. There are specific keypads, one inside his bedroom, one outside his bedroom, and then he has a separate system for his bedroom alone, which is apart from the system that was shown on the diagram.
You have security system, separate security system for the bedroom?
Yes.
Thank you.
Ms. Chapman? All right, Ms. Silva, thank you very much. You're excused as a witness.
Thank you.
All right. Mr. Cochran, you accept on behalf of your client?
Yes, I do, Your Honor. You may say.
All right, Mr. Darden, you want to offer the stipulation? Or Ms. Clark?
I'm going to read it in with the court's permission, and then lodge the paper with the court.
All right.
Is that acceptable?
All right, Ms. Clark, you have a stipulation to offer at this time?
I do, Your Honor.
All right, would you read that slowly, clearly, so the jurors
Yes.
can hear it?
And
All right.
read it to the jurors.
Thank you.
It is hereby stipulated that the following cellular telephone records, which include records that have been marked as exhibits in this case, were prepared in the normal and regular course of business at or around the time of the information contained within the records, and that the records accurately reflect the information contained therein. And that is for the following records: the cellular telephone records for the date of June the 12th, 1994, for the cellular telephone located within the Town and Country limousine driven by Allen Park on June the 12th, 1994. The cellular telephone records for the dates of June the 12th and June the 13th, 1994, for the cellular telephone belonging to the defendant, Orenthal James Simpson, and the cellular telephone records for the date of June the 13th for the cellular telephone belonging to Detective Ron Phillips.
All right, Mr. Cochran, is that stipulation acceptable to the defense?
Yes, so stipulated, Your Honor.
All right, then the stipulation is accepted by the court. Ladies and gentlemen, a stipulation is an agreement between the attorneys as to certain facts, and you were to accept those facts as true for the purposes of this trial. All right, counsel, at this point, I'm going to take a brief recess, and I'd like to confer with counsel in chambers with the court reporter, please. All right, ladies and gentlemen, we're going to take a recess at this time. Please remember my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Do not conduct any deliberations, and do not allow anybody to communicate with you regarding the case. And we'll see you back shortly. All right? We're represented by Mr. Clark, Mr. Harmon, and Ms. Kahn. All right, Mr. Scheck, you had wound up your comments?
Yes.
Thank you. Mr. Neufeld. Or was Professor Thompson next?
Do you want the prosecution to respond to this? You want us to go through everything?
No, I'd like to hear the whole motion.
Okay.
Okay. On the motion on defendant's objections, you heard the whole argument.
Okay?
Those were different applications, and you said you want to do one first.
Yeah.
All right.
There's the separate matter of the prosecution's motion to eliminate to restrict our inquiry on gentleman's evidence.
All right, then I'll hear from the prosecution on this first matter.
Okay.
Mr. Clark.
Thank you, Your Honor. With regard to this motion by the defense, I think there's a number of factors the court has to take into account. Initially, to a large extent, I believe Mr. Scheck merged two of the motions that are before the court today. He had a great deal of discussion not only about whether or not the defendant's right to a Frye hearing should basically be resurrected at this point in time, and he also intertwined with that discussion numerous comments that involve cross-examination of the people's witnesses, for instance, about DNA evidence, as well as proper methods and procedures to actually weave that cross-examination with the opinions of other experts and so forth that Mr. Harmon will address in subsequent comments. I'm going to restrict myself to the actual motion or actual notice of objections as the way it was characterized and what this court should do, in our view, with respect to that particular motion. That is a motion. It's not a notice of objections. It is clearly a motion by this defendant to have this court convene an admissibility hearing pursuant to Kelly and Frye. This defendant seeks relief from his January 4th of this year waiver of his right to challenge DNA evidence as sought to be introduced by the people in this particular action. While this defendant's acts yesterday and today by way of this motion are understandable from the facts of this case and the nature of the DNA results that have been obtained, that does not in any manner change the fact that this evidence is admissible, and this evidence is admissible because of the very acts undertaken by this defendant prior to today. And I want to go through those facts because I think they are at the heart of this particular motion, and I'll do that in just a moment. But initially, I think it's important for the court to note the very...
Sorry, Mr. Clark, let me ask, forgive me for interrupting you, but there's one other staffing issue. Does anybody have need of our evidence presentation system for the afternoon? If not, I'm going to excuse Ms. Fitzpatrick for the afternoon.
There is some possibility in the course of my comments, and they're going to be reasonably brief. So if it would be acceptable for that to...
What type of exhibits are you contemplating using?
Possibly a videotape.
All right, videotape I can do myself because I've got my own system. All right, Ms. Fitzpatrick, you're excused.
Very good. As far as the broad nature of what this defendant seeks by this notice of objections, I think the court can take in summary fashion that they address approximately 6 broad areas. Those 6 areas include a request that this court, sitting alone without a jury, in fact conduct a FRI admissibility hearing about what the defense characterizes as new results. Those results, as the defense notes, were, quote, new results if in fact they were received by them following the January 4th waiver by this particular defendant of his right to challenge admissibility. The second broad area is a request by the defendant to convene in the presence of the jury again, which is not a unique proposal by this defendant, a FRI hearing applying to both the old results, and by old I mean those results released to both parties prior to January 4th of 1995, as well as the, quote, post-January 4th results that are, for lack of a better term, the newer results. The defense has also asked that this court convene a Kelly inquiry pursuant to prong 3 of People v. Kelly, dealing with whether or not correct scientific procedures were used, and to in fact conduct that hearing outside the presence of the jury. The defense has also suggested that this court must rule on how population frequency data must be both calculated by scientists as well as presented to a jury. The fact that, as the defense alleges, error rates must be characterized in a particular fashion, and in fact allegedly incorporated into population frequency, as expressed to the jury via the various DNA experts that will testify at this trial. And finally, and again a broad area, limitations on how experts can convey the meaning of mixed samples, and in fact how it can be characterized to a jury that more than one donor may have been or was involved in a particular DNA sample, and how that fact can be characterized to the jury must be litigated before this court sitting alone. As I mentioned a few moments ago, at the heart of this motion is what occurred prior to today. And the court, I think, has to go back to October 4th of 1994, in which the defense filed a very extensive motion to exclude DNA evidence. That motion attacked, first of all, the particular technologies involved in this case. Those particular technologies, in broad strokes, the defense characterized as not meeting the general acceptance standard of People v. Kelly and Fry v. the United States. And in fact, it was alleged by the defense that not only did DNA typing not meet the general acceptance standard, but in fact the 2 primary approaches utilized in this case suffered from an absence of general scientific acceptance at each of the major steps of those particular processes. And that includes both the restriction fragment length, or RFLP, testing approach, as well as the PCR testing approach as utilized in this case. In addition to that, the defense in broad strokes characterized what it believed to be a lack of general scientific acceptance of the manner in which population frequency data are both calculated by testing laboratories as well as expressed to juries in criminal cases. The second broad area that motion attacked was the alleged failure of laboratories in this case to use proper testing procedures, or what can I think be safely characterized as the third prong of our Kelly inquiry in the state of California. The third major area was an allegation that under Evidence Code Section 352, that this evidence, even if otherwise admissible pursuant to Fry and Kelly, nonetheless should be excluded by this court from consideration by the jury because of the excess of its prejudicial effect when compared to its relevant and probative value before the jury. And then finally, the defense alleged under People v. Griffin that due to supposed failure of each of the testing laboratories to utilize proper collection techniques in terms of evidence collection, handling, and processing, that this court should therefore preclude admission of DNA testing results as well. The next significant act that occurred with one exception that I'll address a little bit later, was on December 13th of 1994, in which, as this court is fully aware, the defense proposed to this court a novel proceeding in which the court would allow this DNA evidence to be heard by the jury, but the court would conduct a concurrent or simultaneous Frye hearing, at which the defense would, while running the risk that a jury might hear evidence of DNA typing results and matches and further, that the defense was willing to take that risk and then have the court instruct the jury, if necessary, that they were to disregard the evidence of DNA typing results that they heard. This court rapidly denied that and, in fact, in December, set this case for a Frye hearing on January 5th of this year. Immediately prior to that date, and in fact in a motion dated January 3rd, 1995, the defense filed its notice of withdrawal of its motion to exclude DNA evidence in this case. In that motion, the defense specifically stated its intent to give up that right to an admissibility hearing and to, in fact, challenge the weight of this evidence before the jury, to challenge the weight of that evidence before the jury as to the reliability of the testing procedures that were utilized, to challenge the weight of that evidence as far as statistical frequencies or population frequency data and what weight the jury should give to that evidence, and in fact to challenge before the jury the specific techniques that were used in this particular case. The methods that the defense suggested in that motion by which they would challenge that evidence, and again in front of the jury, where cross-examination was specifically stated to be one of the greatest areas that the defense intended to utilize to challenge the weight, again, that this jury should give that evidence, as well as to present defense evidence as to why the particular results in this case should not be believed by the jury. Finally, the defense stated that they would utilize any appropriate means in front of the jury to again challenge the weight of the particular evidence presented by the prosecution's DNA experts. In the course of the hearing on that withdrawal, in the course of the hearing on that waiver, the court and counsel were both presented with a series of proposed questions to be asked of the defendant to ensure the defendant's realization of what he was giving up, what right he was waiving as a result of withdrawing that initial motion to exclude. And in the course of that hearing, as the court I'm sure is familiar, not only did counsel for Mr. Simpson waive the right to any hearing on that motion to exclude evidence and waive the motion itself, but the defendant personally waived that right as well. And fortunately, a videotape captured that entire 8 minutes, in which the court asked questions of counsel, asked questions of the defendant himself, and in fact ensured that what the defendant was giving up was clear to the defendant, his counsel, and in fact all the parties to this action. The significance of that act was to allow the admission of DNA evidence in total, because the defendant gave up that right to challenge under Frye and under Kelly and under any of the three prongs of Kelly admissibility of the evidence. And in fact, I think that's the key act itself. The defendant, by this motion or by this notice of objections filed last week, attempts to disavow his own acts in giving up that right on January 4th of 1995. And in fact, yesterday the defense has sought to convince this court that its initial proposal or its proposal in December of last year to convene this hearing in front of the jury should again be authorized by this court. And I think the court should be aware, certainly is aware, that it's simply an attempt to raise what was given up before. Now, briefly, what does the current notice of objections do? It really addresses four major areas, one of which I've already spoken about. It's an attempt to resurrect the same claims that were made in the October 4th, 1994 motion to exclude. The defendant claims, and this is the second major area of the new motion, that he didn't even know the procedures that were used as far as testing in this case until he was provided raw data as recently as January of this year based on testing, for instance, conducted by the California Department of Justice. He renews his argument under Evidence Code Section 403 that in fact this is really not a hearing under People v. Kelly or Frye v. the United States, and that in fact it's a foundational or preliminary fact hearing under our Evidence Code scheme in California. And lastly, the defendant contains that the landscape's different, that because more testing has occurred, the situation is different, and the court should take a different course from that adopted by this court in December of 1994 and as set by this court as a result of the defendant's waiver in January. Well, all of those claims are without merit. The first I've already discussed. The same arguments in the motion before this court filed last week are the same arguments that were before this court in the motion to exclude in October that was specifically withdrawn by this defendant on January 4th of this year. The claim that the defendant had no opportunity to know the procedures used in testing in this case, and I'm referring to DNA testing, at the time of his January 4th waiver is totally belied by the facts of this case. The protocols, the procedures manuals utilized by not only the Los Angeles Police Department, but also Cellmark Diagnostics and the Department of Justice were provided months ago to this defendant, and in fact in approximately the late summer, early fall of 1994. As of the time of that January 4th waiver, the defendant had been provided extensive raw data by both the Los Angeles Police Department and Cellmark Diagnostics, setting forth the actual testing procedures and detailed notes about what occurred in this particular case. As to the Department of Justice, I think the circumstances are even more compelling. Dr. Blake, as the court has been made aware on many occasions, carefully monitors what goes on at the Department of Justice in terms of testing in this case. And to somehow avow that the defense was not able to learn about testing procedures at DOJ prior to January 4th, I think is extremely suspect. Particularly pertinent to the Department of Justice is the fact that on that date of January 4th, when the defendant waived his right to an admissibility hearing, it was clear that the report and raw data from DOJ were imminent and in fact were expected by all parties to either arrive on that date or the next day. And in fact, this defendant didn't even ask this court for one more day to in fact receive that material before it made the major step of withdrawing the motion before this court filed in October. I'm not going to reiterate the arguments about Evidence Code Section 403 because I'm sure the court is aware that was briefed and argued to the court extensively back in December when the defendant's proposal for a modified type hearing was before this court. Suffice it to say, 403 is inapplicable in the state of California as to DNA evidence because Kelly, as we know from the cases cited in our responding papers, is the exclusive means in California of determining the admissibility of newer novel scientific evidence as stated by our Supreme Court in both In re Harris as well as the more recent People v. Leahy. To somehow attempt to parlay a question of fact and law, a mixed question of fact and law, to be made by the court into a jury determination, as was noted back in December, I think is clearly contradictory, and frankly, it makes no sense whatsoever. The last argument raised by this defendant in the course of this motion, I think, is the most mysterious argument. And in fact, in this motion, the defense claims that testing for which results were provided after January 4th, 1994, and in fact testing that occurred after January 4th, 1994, involves novel procedures. I think that's exactly the way the defense characterized it. The truth is the same testing procedures have been used after January 4th as were the testing procedures utilized by laboratories in this case prior to January 4th, and the court specifically authorized testing to continue. This court refused the defense demand for a cutoff date. So the fact that further testing occurred, which certainly complies with California law, the fact that that testing occurred and produced results was no surprise to anyone because this court specifically authorized that particular procedure. In that vein, and perhaps what makes this argument so curious, I think, is the fact that when this court had been presented with the original motion to exclude evidence, this court received a letter from the defense dated October 18th, and I believe signed by Mr. Neufeld. And in that letter, the defense specifically stated, since the Kelly issues are limited to methods and procedures, disclosure of the actual test results is not required. The claim today in this current motion contradicts the earlier claim about results, and it contradicts what exactly the defense claim is about what prong 3 is. As this court is well aware from extensive pleading filed in the fall of last year by the people, results aren't relevant to the determination of the use of correct scientific procedures under prong 3. So I think for the defense to be claiming anything which contradicts that earlier letter of October renders the claim today particularly without merit. This defendant knowingly waived his right to challenge evidence in terms of DNA results and their admissibility on January 4th of this year. That decision was a tactical decision It was made after consultation with his attorneys, and in fact, it was personally waived by this defendant in court. This defendant has never been forced to choose amongst rights. He has controlled the timing of this case in terms of the beginning of trial and the continuation of trial within the meaning of the Sixth Amendment and the right to speedy trial. This is an 11th hour attempt to stall trial, and I don't think it can be characterized in any other fashion. And I think when the court incorporates, and I'm confident when the court incorporates, that this late attempt is designed to stall this trial, that when the court weighs that fact against the people's right to due process under the California Constitution, that the court should deny in total this particular notice of objections and any attempt by this defendant to force this court to convene the admissibility hearing that Mr. Simpson personally gave up on January 4th of this year.
Thank you. Thank you, Mr. Clark. Mr. Scheck?
This motion is not an effort to stall the trial, and I think that Mr. Clark has misunderstood what we're suggesting to the court. Let me be specific. As to the chart that we introduced yesterday in the motion that we submitted, and I'm putting aside now the first prong of Kelly Fry, we're talking about third prong objections. Third prong is interpreted by the decisions in Barney and Wallace and Pizarro, which is not the interpretation that Mr. Clark and Mr. Harmon have urged upon this court and have urged upon those courts in other litigation, where they say the actual results and the actual way the tests are performed have no relevance to prong 3. That argument was rejected in Barney, it was rejected in Pizarro, it was rejected in Wallace, and the California Supreme Court in the Leahy decision specifically said in response to Mr. Harmon's brief that they're not going to entertain that argument either. So I think that our interpretation that prong 3 has to do with the way the actual tests are performed, whether, for example, controls failed such that the test's results are not reliable enough and should be struck from evidence, is a question that I think this court has to consider as the test results come in. Let's be very, very clear, as I tried to be yesterday, and that is, in terms of just laying it out, and that is, we're only asking this court, gets me nervous when you smile like that, the first two issues having to do with statistics and the way they're presented to the jury and the need to present DNA in the form of statistics and the instructions that we're asking the court to consider on that score, Mr. Clark never responds to it. They seem to be insisting by his silence that they're entitled to introduce this evidence without statistics. He doesn't even respond to the point. I think that's just plainly wrong. That's the only issue we want you to decide right away. The only other issues as to whether or not the tests were performed correctly, whether they're reliable enough to be considered eventually in the end by the jury, whether prong 3 has been violated, whether specific things mentioned in Barney and Wallace have been violated, whether the Collins and Sella arguments apply, and most importantly, whether 352 applies to the way the statistics are presented and the way the evidence are presented. We think all those arguments plainly should be heard by the court after you hear the testimony from the prosecution witnesses, they're cross-examined, and you hear testimony from defense witnesses. Then at the end, you can make a determination. I think that's the only sensible way you could make a determination as to whether or not some or all or any of these DNA test results should be heard by the jury. That's what we're proposing with respect to all these non-prong 1 objections. So it's no attempt in that regard to delay the trial at all. I think that in Mr. Clark's recitation of the history of how these hearings were scheduled and not scheduled, I think he's leaving out a lot. As I'm sure the court recalls, these DNA hearings were scheduled before jury selection, in the middle of jury selection. Proposals were made by the court, made by counsel to the court, and the court had indicated some desire to pursue it, that we have limited number of witnesses. We asked for, on both sides, that you entertain transcripts from other witnesses from prior proceedings, take judicial notice of those, that we segregate the issues, that we do it in an organized, quick way, that we try to take care of this in 2 or 3 weeks. The prosecution resisted all of that and insisted upon calling 22 witnesses. So if anybody wanted to delay, at that point it was them. At one point, and this is what's so fascinating, the prosecution actually had suggested, well, we can hold a Kelly hearing only on prong 1 issues, and then the prong 3 issues can be entertained at trial. So at one point they even made that proposal as we were going back and forth on the scheduling of this during jury selection. What Mr. Clark just doesn't respond to, and is the central thrust here, is that in our motion to withdraw, we do not waive our right to attack the reliability of the evidence and perhaps have this court ultimately rule that some or all of it should not be considered by the jury in the end because of the way the tests were performed, whether they used correct procedures, and certainly 352 objections and objections under Sell and Collins as we lay out in our arguments. That's all we're asking you to do. I don't think that it would really be possible to make a sensible decision on those objections without hearing the evidence. But on that first point, which they don't respond to, which I find quite disturbing, that this evidence must be presented with statistics. And our further suggestion, if you agree with us on that point, and I think it's the holding of Barney, it's what the National Research Council has suggested, I think it's the overwhelming weight of sensible precedent, whether you're in a Frye or a Daubert jurisdiction, that the evidence is statistical. That the court further instruct, and we will present a suggestion to you, if you agree with this first point, as to these are just gene frequencies, and there are other probabilities that affect the weight of the evidence that you should consider about error rates in the laboratory, errors in the laboratory, errors in the collection, or even the probability that the evidence was tampered with. And these are things that I think the jury has to know in order to fairly evaluate the evidence so that they don't think that this astronomical statistic they're going to hear is a probability of guilt or a probability that Mr. Simpson is definitely the source of the blood drop on the driveway and all other ways that these things can be conflated, particularly since of the tremendous danger there is of jurors evaluating statistics, lay people evaluating statistics, which can be very misleading. That's the 352 argument. It's a prong 3 argument. It's the only one that we really want you to resolve now, or we think you can. As far as this notion that we would really have known exactly what had been done at DOJ because Dr. Blake went there and took pictures of the gels and was monitoring what Mr. Sims was doing. Before we look at his results, before we look at his run notes, before all of that is evaluated and we see what he actually is interpreting things as, and before, frankly, we even hear him testify as to what the meaning of certain results are, we can't lodge our objection specifically and properly as to where we think the evidence is fatally unreliable. Now, that could happen, obviously, outside the presence of the jury, but we're not suggesting that. It should happen in the presence of the jury, and then we lodge our objection under prong 3. We're not asking for a prong 3 determination outside the presence of the jury to delay the trial. We're not asking for that. Finally, with respect to the issue of prong 1 on the new test results, I'm not going to, I think the record's clear about the nature of the withdrawal and what happened on the record, and the court noted itself that Mr. Simpson was saying that he understood what was going on. He'd been advised by his counsel as what the legal implications of all this was. But with respect to what he was authorizing and what he was talking about, he was saying, I understand, and the withdrawal of the motion is set forth by my lawyers, and that's what he did, and the court noted that for the record. So I don't think that you can get any kind of blanket waiver out of his statement. It doesn't make any sense. We withdrew the motion, we waived an outside the presence of the jury hearing on prong 1 for sure. We were not waiving, didn't intend to waive. I think it was clear to the court even when we did it. We knew we'd be revisiting this. Third prong challenges, 352 challenges, the challenges that we've laid out. Now with respect to the new test results and prong 1. I think, for the reasons I stated yesterday, and the way the testing was performed strategically, that, and the whole way that this litigation has evolved, that we're entitled to a prong one hearing outside the presence of the jury on these new results. We're entitled to it. If we're entitled to that, what we should certainly be entitled to is the alternative we propose to the court, and that is that we do this in the same fashion and form that we suggested to the court in December, and that is we proceed with the trial just as it's supposed to occur, just as the prosecution has planned. They present their witnesses. If they feel that they have to call other witnesses outside the presence of the jury on some other days to build foundation, they can do so. And we will present our witnesses in the defense case, and then at the end the court can decide. That alternative waives the prejudice that a defendant would otherwise suffer if the results were heard by the jury and then the court ultimately struck them. So we think we're entitled to the hearing, but we would propose to the court the alternative. If the court doesn't accept the alternative, I mean, we have no choice but to ask for the hearing, but it's the alternative that obviously we're interested in here.
Thank you, counsel.
The way we think about this, I think the next order of business is Mr. Harmon's motion, to which Mr. Thompson will respond.
All right. Mr. Harmon.
Thank you, Your Honor. It sounds like reliable has a lot of different meanings depending on when you say it and what you intend to communicate and what you really mean by it. Clearly, under California law in these areas, it has two different meanings, and I've laid them out in my motion because they have profound significance. And even on this motion, it might be helpful to watch the January 4th proceedings to see how words were being used to mean other than what was patently obvious to everybody in the room. Because one can't look at that tape and not realize that these discussions were inevitable. There was an opportunity to finally resolve it, but that's not what people had in mind. So reliability in the two contexts, in the January 4th context, the reliability that was at issue clearly has to do with what people think about the methods that are used. And clearly under California case law, that reliability can be demonstrated, and the only practical way to demonstrate it is by hearsay testimony or hearsay opinions from other people, articles, things like that. But that reliability changes once the court makes the finding, the mixed question of law and fact, into a straight finding of fact by a jury. In a jury trial, the fact finder, which is what we call them, we don't call them the mixed question of law and fact finder. Those people are fact finders, and they don't actually find specific facts. They decide whether something's been proven beyond a reasonable doubt. But reliability in that context simply means, do the tests work? Not do other faceless, invisible people who've never written scientific articles, do they think it works? Or do they have qualified reservations about it that they write to the National Association of Criminal Defense Lawyers and put in their binders so that we can regurgitate these things in front of juries? It's whether or not the tests produce the correct answers. That's the only fact issue in that context that the jury gets to decide. And so the brief that I filed, it was clear on January 4th that I would be filing a brief such as this because it was clear that regardless of the December ruling by you and regardless of the clear, unambiguous waiver on January 4th, that the defense team had every intention, regardless of any kind of ruling by you, of parading all sorts of unreliable hearsay in through cross-examination of the prosecution witnesses. That was never in doubt. That is the only way to confuse the jury and distract them from the only issue, and that is, are the tests in fact reliable? So, when the defense filed the motion that Mr. Clark just responded to, it became important to take this brief out of the can and just file it along with it, because they are totally connected, in fact, at this point in time, and they're totally connected in the kind of assessment that you have to make in this point. Perhaps, what we've in discussions about personal attacks being made. One of the examples of the kinds of hearsay that gets paraded around is on page 16 of the brief that Mr. Clark responded to. And these are the kinds of scandalous, baseless things that get perverted and paraded across the country. That's the footnote 12, the accusation, the personal accusation that Ms. Clark has previously misrepresented things in her presentation to jurors. And in fact, if the court were to read the actual article that the colleague of the defense team has written on this point, the court would see very clearly, and that's one of the exhibits that was appended to the defense's admissibility brief, that in fact, Ms. Clark never misrepresented anything in her presentation. The article is on the Cardozo Law Review. It's footnote 7. Everyone on this side of the room knows exactly what happened. The questions that were asked of the scientist, and these were in context of prior questions and subsequent questions, they were asked by the court for people to say, as was done in the brief, and as Mr. Scheck took a great advantage of yesterday, this is the second time Ms. Clark has done something like this. It's not the second time. It's not the first time. The court asked the question, does that mean it's consistent with his being the father, or it's 100% certain that he is the father? Answer, in my opinion, he is the father. And then the court asked another question. These are the kinds of low-level, unreliable, prepackaged things that will certainly be introduced into this trial through cross-examination of our witnesses should the court not adhere to the clear rule of law in this state. I can't speak to what the rule of law is in other states, but Section 721 simply stands for the proposition that it is inappropriate to cross-examine any expert on material that that expert has not referred to, considered, or relied upon. And I think by Mr. Scheck's comments yesterday, it is clear that they are outraged at the possibility that they will not be able to cross-examine expert witnesses on the kinds of material that they want to interject into this case, the kinds of things that are hearsay. I use Dr. Mullis as an example. I used him as an example only because he has never published any scientific article critical of the techniques used. I invited you in my motion to review his testimony that was appended to the defense's brief in opposition to the admissibility of DNA evidence. It's hardly what you would call a scathing indictment of the forensic application of PCR. But those are the very kinds of things that the defense intends to elicit on cross-examination of our witnesses, even though our witnesses have not referred to, considered, or relied upon them. And there's a very good reason that they want to do it that way. And the reason is because that denies us the opportunity to cross-examine those people. And as I alluded to in my brief, there are very good reasons the defense does not want us to cross-examine the experts that they'd like to get in through hearsay. We would love to cross-examine each and every witness that the defense would like to hold out as voicing some opposition to the actual reliability of the tests produced in this case, which is the only reliability left now that they've waived their hearing. Unfortunately, we'll never get to cross-examine Dr. Blake because they just dropped him like a hot potato from their witness list. That was no surprise. If you listen and think back very carefully on Mr. Scheck's arguments yesterday, they have somehow merged two legal principles in this area, two evidence code sections, and that is what sort of material an expert may reasonably rely upon in providing expert testimony and opinion testimony in a case, and use that concept to obliterate the restrictions on cross-examination of experts that I've alluded to in Evidence Code Section 21. And if you allow that sort of merger, the sort of perverse principle that comes out of it is they get to decide what our witnesses should have relied upon. And when they get to decide what they should have relied upon, then they get to cross-examine on all this baseless, faceless hearsay that they certainly seek to introduce in this case, not from their witnesses, but from our witnesses. We do not seek to impose any restraints other than other evidence code provisions and other case law provisions, such as in People v. Korish, on their efforts to convince this jury that, in fact, our results are unreliable. Now, that's going to be pretty hard in this case, Your Honor, because the only way they could do that is if they retested our evidence through DNA testing. Mr. Scheck expressed concern that someone, a Nobel Prize winner such as Dr. Mullis, would have to answer personal questions. Well, the last time I looked in the California Evidence Code, we didn't have an exception for Nobel Prize winners. That everybody that steps up there and raises their hand, they're a witness. If they're a Nobel Prize winner, that's fine. They're a witness first. And every witness's credibility is open to the same considerations. Did I have a dream, or did I see Ron Shipp being raked over the coals about virtually every aspect of his personal life? Did I dream, or did Denise Brown have to do the same thing? And what did those two people do to deserve that? Ron Shipp was the defendant's friend. That's the payback that he got. Denise Brown had to see her sister taken away from her. Now, do we have to treat a Nobel Prize winner any differently just because they want us to? I don't think so, Your Honor. We'll see, but I'm telling you, that day will never come. If this court adheres to Evidence Code Section 721, the case that's cited, and Jefferson, he'll be a blip on the radar screen. He's not going to sit up there and testify because he has nothing meaningful to add about the actual reliability of our test results. I urge you to follow the clear law on this point. I'm anxious to hear a legal response to our in limine motion. I brought it up to the court because it was clear on January 4th we would have to have this discussion. Thank you.
Thank you. Mr. Thompson.
Good afternoon, Your Honor. Before I respond directly to Mr. Harmon's motion, I want to respond briefly to his point about footnote 12 of the Notice of Objections and the statement that Ms. Clark had previously presented testimony in the form that we consider objectionable. I wrote that footnote. I wrote it based on a careful review of the transcript. We will submit the transcript to you so you can see the entire thing in context. And we continue to regard that transcript as an excellent example of the type of testimony that we think is inadmissible under California law on the grounds that we laid out in the notice of objection. All right, now let me turn to Mr. Harmon's arguments.
All right, Mr. Thompson, when do you anticipate lodging that with the court, the complete transcript? I'd like to see that.
I could file the transcript as soon as tomorrow, Your Honor.
Fine, thank you.
All right. All right. Now, Mr. Harmon's motion here is an effort to restrict the ability of the defense to inquire of prosecution witnesses concerning the general acceptance of the techniques that are being used here. It goes further and attempts to limit testimony by defense witnesses regarding the opinions of people in the scientific community concerning these techniques whose reliability is at issue in this case. Now, Mr. Harmon makes a series of distinct legal arguments for his position, and I think it would be useful to go through them one at a time to try to disentangle them and show you why we think they're all groundless, and that we have a perfect right to engage in inquiry in these areas, subject to obvious limitations imposed by the hearsay rule or Section 352. Now, the first argument that Mr. Harmon makes in his papers is that the defendant is somehow precluded from inquiry on general acceptance by virtue of the determination of preliminary facts arising under Kelly. In other words, somehow we are bound or limited by virtue of the fact that there is a determination of preliminary fact regarding general acceptance. Now, I think in evaluating this claim, the court should keep in mind the distinction that's drawn in Article 2 of the Evidence Code, that is Evidence Code Section 400 through 406, between preliminary fact on the one hand and fact in issue on the other hand. Preliminary facts are, of course, facts that are decided by the judge in order to determine the admissibility of evidence, and general acceptance within the rubric of Kelly is a preliminary fact. Facts in issue are to be decided by the jury. So the basic legal point raised by this argument is whether and under what circumstances a determination of preliminary fact is binding on the jury or places a limitation on inquiry by a party. And the answer that's very clear from the Evidence Code and the case law is never. Never. There is a complete wall of separation between the preliminary fact determination and the determination of fact by the jury. This is made perfectly clear in Evidence Code Section 406. The Article 2 encompasses 400 through 406. Section 406 states very clearly, this article does not limit the right of a party to introduce before the trier of fact evidence relevant to weight or credibility. Nothing about the preliminary fact determination limits what can be presented to the jury. I think if we think about this for a minute, it's clear why that must be so. It must be so as a matter of constitutional principle. For one thing, for the preliminary fact determination, a judge's issue, to be imposed on the jury, the trier of fact, would invade the province of the jury on the very facts which have traditionally been left to the jury, such as the reliability of the evidence. And it would invade the province of the jury in a particularly dangerous way because there is a different standard of proof for preliminary fact determination by the judge and for fact and issue determination by the jury. In the context of a criminal trial, the standard of proof for the jury is beyond a reasonable doubt. What Mr. Harmon's proposal would hold is that if the prosecution can, by a preponderance of evidence, convince the court that a particular technique is generally accepted, then that holding would be imposed on the trier of fact, the jury, which has a beyond reasonable doubt standard. So it invades the province of the jury. It undermines the presumption of innocence and the correct burden of proof. Now, there are a number of examples in California law that illustrate the fact that this fact of separation between preliminary fact determination by the judge and fact and issue determination by the jury. One example that comes up is the determination of the reliability of a lineup. Often as an issue of preliminary fact, the trial court has to decide whether a lineup is reliable. If the judge decides that it's sufficiently reliable for the lineup identification to be admissible, then the issue comes up, does the judge's determination of reliability pose any limitation on how the defendant can attack the reliability of the lineup at trial? Answer, no. The answer is very clearly no, and I refer you to People versus Rodriguez, 88 Cal Reporter 789, or 10 Cal App 3rd 18, which stands for this proposition that the preliminary fact determination of reliability of a lineup is in no way binding on the jury. The same issue comes up with regard to the preliminary fact of the reliability of a hearsay statement. The judge must determine as a preliminary matter often whether a hearsay statement is sufficiently reliable to go to the jury. If the judge determines it's reliable, does that then mean that that's somehow binding on the jury, or that limits what litigants can do? Obviously not. Obviously not. And the evidence code says so. I'd refer you particularly to the Judiciary Committee's comment to Evidence Code Section 405, which says explicitly that this sort of limitation does not apply. I think this point is also easily inferred from the structure of the rules themselves. Some issues of preliminary fact determination fall under Section 403, some fall under Section 405. With regard to those that fall under Section 403, the law requires that the jury be allowed to redetermine the fact, and if requested, instructed to determine the fact. And in fact, with respect to DNA evidence, we know some issues do fall under 403, despite what Mr. Clark said, because we are instructed so by the Court of Appeal in People v. Pizarro. In Pizarro, the Court of Appeal said that issues of preliminary fact determination regarding the adequacy and relevance of a database fall under 403. They are issues to be redetermined by the jury. So obviously, if it falls under 403 and the jury is going to redetermine it, then the judge's determination has no limiting effect. Other determinations fall under 405. With respect to those falling under 405, though, again, there's this wall of separation. Section 405 says, in part, 405B, that if the preliminary fact is also a fact at issue in the action, it says, quote, the jury shall not be informed of the court's determination as to the existence or non-existence of the preliminary fact. And if the proffered evidence is admitted, the jury shall not be instructed to disregard the evidence if its determination of the fact differs from the court's determination of the fact. So this argument that the determination of preliminary fact with respect to Kelly somehow limits what can be done in front of the jury is simply a non-starter. There's no basis for it. Mr. Clark suggests that Article 2 of the Evidence Code may somehow be inapplicable to Kelly determinations. He cites no authority for that whatsoever. I don't buy the argument. But even if it's true, and even if Kelly is somehow separate, the idea that the Kelly determination limits the kind of challenge that can be made in front of the jury once the evidence is admitted is belied by the very language of the Kelly cases. I'd refer you, for example, to there are two interesting cases where Kelly-Frye challenges by the defense were resoundingly rejected by the court, and courts held as an issue of preliminary fact that serology tests were admitted, where the Court of Appeal comments on this. One is People v. Smith at 215 Cal App 3rd 19. After the trial judge took judicial notice of the reliability of the serology test, the Court of Appeal notes that, quote, appellant had full opportunity to cross-examine the prosecution's serologist's qualifications and methods and to present whatever evidence he desired challenging them. Whatever evidence he desired. Similar language can be found in People v. Cooper at 281 Cal Reporter 90. Again, this was a case where the defense mounted...
Just so counsel are aware, Cal Reporter sites don't do me much good as a practical matter.
All right, I can provide a more specific site.
No, I know I'm familiar
to-
with the case. I'm just saying that doesn't help me since I only have the official reports.
Okay, thanks. I'll try to stick to those to the extent I have them. But Cooper, again, that's the same issue. The defendant's pretrial challenge under Kelly to a serology test was resoundingly rejected by the court. The court determined that it was reliable as a matter for Kelly. Does that then limit the attack on reliability in front of the jury? No. The Court of Appeal says, quote, defendant was allowed to cross-examine the prosecution's serologist fully about his qualifications and the manner in which he did the testing, and to present whatever additional evidence he desired. Again, whatever additional evidence he desired. So this argument that somehow the Kelly determination precludes lines of inquiry has no basis in law. It's a complete non-starter. Well, there's a second argument I want to turn to now, and that's the argument Mr. Harmon makes that somehow inquiry onto general acceptance issues lacks relevance. It's simply not relevant, he suggests, to inquire in front of the jury regarding the opinions of the scientific community about the techniques in question. And he draws this distinction between admissibility, reliability, and actual reliability, arguing that they're two different things. Now, in fact, I find no authority whatsoever in California law for this distinction between admissibility, reliability, and actual reliability. I think he's simply confused. The real distinction is between preliminary fact and issue. There's no support for the admissibility versus actual distinction. And the fact that inquiry in these areas is relevant, I think, is pretty obvious. Inquiry about the opinions of other scientists could be relevant on a number of issues. It can be relevant to the direct issue of reliability, which the jury has to assess. Knowing, for example, that there are scientists significant in number and expertise in the scientific community who consider a particular test procedure unreliable.
How do you deal with 721 of the evidence code then in that argument?
All right, well, let's turn to that. I mean, if you accept that it's reliable, I certainly, the 721 argument, I think, is a different issue from relevance. But I'll talk about.
Let's assume that the context that you've just placed that argument, though, is in the cross-examination of prosecution experts.
Yes.
So that's why I bring up 721. How do you deal with that limitation?
Okay. Well, the limitation of 721 has to do with cross-examining experts about documents, treatises, and so on, about which they're not familiar. All right. Now, Mr. Harmon suggests that this limitation applies not just to...
721 doesn't say anything about familiarity,
though. That they hadn't considered, that they hadn't relied upon, and that hadn't been admitted into evidence. Okay. So, the witness, it says under 721, Section 1, the witness referred to, considered, or relied upon such publications in arriving at his opinion. Okay. Well, with regard to the opinions of other scientists, a number of lines of inquiry are possible under 721. First of all...
See, what I'm concerned about is that on either side, if either side calls an expert witness, I'm sure there are theories, the ones that, for example, that were mentioned yesterday regarding non-related controversial issues that someone would want to cross-examine on that are just so far out into left field that are ridiculous. I mean, do I have to allow that in cross-examination?
No, that would be subject to exclusion under 352 as irrelevant.
Okay.
You know,
all right, we agree on something.
All right. Well, I hope on more than one thing.
Okay. No, you'd be surprised. All right.
All right. But with regard to 721, it's clear that if a question is asked of the expert, are you familiar with Dr. Mullis's testimony on the reliability of this technique, or do you know about Dr. Mullis's position? If the answer is no, then the inquiry would have to stop. The inquiry would have to stop there. But at least we're entitled to...
Let's assume that any expert regarding DNA, and specifically in the PCR context, would be interested in reading the literature as to what Dr. Mullis has to say.
Yes.
They may totally discount what Dr. Mullis has to say about any number of things, but the fact that they've read it and they're familiar with it, do you think that that entitles you then to cross-examine on that?
Yes.
If
Yes.
that expert
If they
has
have
not-
considered it.
If that expert has not relied upon that in forming their opinion.
If I think the language of the statute says if they've considered it, then they can be asked about it. Right. Certainly, we're entitled to inquire as to the state of their knowledge, to determine what it is that they know. I think we're also entitled to propound hypothetical questions to them. Would it change your opinion if you knew that a certain scientist thought such and such, if asked in good faith? Those questions are allowable under 721. There's no hearsay problem with questions of that type. The problem that I have about Mr. Harmon's arguments, both about the hearsay and under 721, is that I think they sweep too broadly. He seeks to limit us from engaging in an entire area of inquiry because he can imagine certain types of questions in that area that would run afoul of the hearsay rule or a Section 721 rule. But in fact, there are other lines of inquiry that wouldn't. And so to exclude us from the entire area because he can imagine questions that would be improper goes way too far and is premature at this point. While we're questioning his witnesses, if he has hearsay objections, he can raise them at that point. If he has 721 objections, he can raise them at that point. And I think that's not a problem. But to ask you at this point to preclude an entire area of inquiry when that area of inquiry is clearly relevant, if it weren't relevant to ask what members of the scientific community who are knowledgeable in these areas think about the reliability of a technique, we would never have a Frye standard. I mean, the whole basis and idea behind the Frye standard is that if you want to know whether a technique is reliable, you should solicit the opinions of people who are knowledgeable about the technique. And as Justice Mosk said in the Shirley case, 18 Cal 3rd 1.
Hypnotism.
What's that?
Never mind.
Yeah, I mean, but you know the famous quote: if scientists significant in number and expertise publicly oppose the technique on grounds that it's unreliable, then one can draw a reasonable inference that it's not reliable. Now, that reasonable inference, the relevance, is relevant for a trial judge in determining the issue of reliability as a matter of preliminary fact. It's relevant for the trier of fact in determining its reliability as a fact and issue. All right. So there can be no blanket exclusion of inquiry in these areas, and if the prosecution has 721 or hearsay objections, let them make them at the time. All right. Now, a couple of other issues come up. One issue that Mr. Harmon raised is the notion of inquiry about alternative scientific techniques. The issue raised by the case of People versus Korish, which he cites in his brief. Now, again, here I think Mr. Harmon is sweeping too broadly. He's trying to eliminate an entire area of inquiry because there may be instances where inquiries in that category...
Well, I view this as a preemptive strike, is what I view.
All right,
this as.
okay. On Mr. Harmon's part? Yes. Well,
Yes.
let's... he's seeking to wipe out whole lines of testimony.
No, I think the tactic is he's trying to sensitize the trial judge to what's coming, is what he's doing.
Yes. Yeah, perhaps. Let me comment a bit more on Korish.
All right.
Though. The Korish is a case where the prosecution presented serological evidence. The defendant called as an expert Dr. Benjamin Grunbaum, who's a distinguished serologist who critiqued the prosecution evidence, and in order to illustrate the nature of his criticism, offered to present a photograph showing how an alternative and, in his view, better technique would have been done. That proffer of the photograph was rejected by the trial court on grounds that there hadn't been an adequate foundation to show its relevance to the fact and issue of reliability of the test that was done, and that was upheld by the Court of Appeal. Now, the problem in Korish was simply lack of an adequate foundation to show relevance. And the fact that the Court of Appeal upheld that decision does not establish any sweeping rule of law that says evidence of alternative techniques can never be presented. It simply means that in that particular case, the foundation wasn't laid. So this notion that we can't, that we're limited from entire areas of inquiry based on a case having to do with foundational adequacy is sweeps way too broadly. If the defense seeks to present evidence regarding alternative techniques, Mr. Harmon can, at the point we do it, raise foundational objections if he has them. Now, I can imagine, for example, that one of the issues that's important to us has to do with the failure of scientific controls for these experiments, or inadequate scientific controls. In order to explain to the jury what it means for a control to fail, or what it means for there to be inadequate controls, we might well, for example, want to show the jury what, in our opinion, a well-controlled experiment would look like. Now, if we seek to present that kind of evidence, I think it will be up to you whether we've laid an adequate foundation of relevance, of direct relevance, to allow it to come in. If we have, you admit it. If we haven't, you don't admit it. But that's a determination to be made by you on a case-by-case, on an incident-by-incident basis as the evidence arises. This attempted preemptive strike is premature, and it sweeps way too broadly. Okay. Finally, let me say a few things regarding Mr. Harmon's comments about Dr. Mullis and his suggestion that he should be allowed free inquiry into personal lifestyle and drug use and other such issues of defendants' experts. His position seems to be that if we're allowed to question his experts about the opinions of other scientists, such as Dr. Mullis, then he's entitled to present evidence concerning those other scientists with regard to lifestyle and character, and with regard to their opinions on unrelated scientific matters, and even on social issues as reasons to disregard their opinion. Now, our position is that this should not be allowed, and there are three reasons for this. The first reason is that it's completely irrelevant. We're talking about scientific experts here. We're not talking about percipient witnesses whose perceptions of a particular matter might have been clouded by alcohol consumption or drug use. We're talking about scientists expressing an opinion on scientific issues. Now, scholars have for centuries recognized that you cannot judge the merits of a scientific argument based on the moral character of the person advancing that argument. This is fundamental. This is absolutely fundamental. Scientific arguments stand and fall on their own merits and on the quality of the analysis that supports them, not on the character or lifestyle of the scientist who's making the argument. Would the Nobel Prize Committee have taken back Dr. Mullis's Nobel Prize had they suspected that he'd used LSD when he lived in Berkeley? I doubt it. I don't even doubt it. Absolutely not. There are many examples, if we look at history, of scientists whose lifestyle may be called into question. It's well known, for example, that Sigmund Freud made extensive use of cocaine. There's an interesting discussion among psychologists as to whether his cocaine use might have influenced his development of the theory of psychoanalysis. But nobody thinks for a minute that whether or not Freud used cocaine has any relevance at all to the scientific merits of the theory of psychoanalysis. Character, lifestyle of Freud is not relevant. With regard to other scientific positions taken by scientists, Mr. Harmon suggests that Dr. Mullis has taken positions out of the scientific mainstream on other topics. Now, we regard this as also irrelevant and subject to 352 objections because it's likely to take us very far afield. I don't think that we want to have a mini trial within this trial about the connection between HIV, virus, and AIDS. I really don't think we do. But in any case, it's irrelevant. Let's look at other scientists. For example, Linus Pauling, for example, who was one of the most respected biochemists ever, had opinions out of the scientific mainstream with regard to the effects of vitamin C. If he came in to testify about issues in biochemistry, would he have been subject to extensive cross-examination about his opinions on vitamin C when that was unconnected with the scientific testimony he was offering? Certainly not. It's simply irrelevant. With regard to these opinions on social issues, for goodness sake, Albert Einstein had a number of opinions on social issues, marriage, socialism, and so on, that put him outside the mainstream. Does anybody think that Einstein's opinions on those issues has any relevance to the scientific validity of the theory of relativity? It's nonsense. Of course not. The only relevance to any of these lifestyle, character, or unrelated scientific issue opinions would come up if there is some direct showing that it affects the witness's perceptions or ability to communicate. So, for example, if Mr. Harmon, had the chutzpah to ask Dr. Mullis, well, let me rephrase that.
I don't for a moment doubt Mr. Harmon's chutzpah to do anything.
When Mr. Harmon,
You've just challenged him like.
When Mr. Harmon asks Dr. Mullis, "Are you on LSD now as you're testifying?" If he wishes to propound that sort of question, I see that is potentially relevant. On the other hand, I think it's terribly prejudicial. So if he wants to engage in inquiry of Dr. Mullis about drug use under circumstances where the questions have some relevance to Dr. Mullis's ability to communicate or perceive something at issue in this case, then we think he can do that, but we'd ask that he do it out of the hearing of the jury to avoid the obvious prejudice that would flow from such questions. But with regard to the scientific opinions per se, and the merits of the scientific opinions, whether he has used drugs or not, or what his opinion might be on other issues, it's completely irrelevant. It's completely irrelevant. Potentially highly prejudicial and likely to lead us off on a merry goose chase that
Do you think
would
he
never
could
end.
inquire into Dr. Mullis's attitudes and opinions regarding the criminal justice system?
I think he can inquire of experts as to any matters that are related to bias. So if he could make a case or a showing that a line of inquiry is relevant to bias, and whether or not somebody used drugs at a particular point in their life, I see no connection between that and their bias with regard to expressing a scientific opinion. If there's some showing of relevance to bias, yes, he can. But we'd urge you to be very careful and circumspect about judicious in allowing such inquiry. Now, there's one strand of this argument that's worth commenting on also. I mean, Mr. Harmon tries to shoehorn the relevance of this by suggesting that I think I read his argument as saying, well, even if these lifestyle and character issues aren't relevant per se, he should be able to inquire about them because his experts think that they're relevant. And I believe the specific statement that he made is that there are scientists that he intends to call who disregard Dr. Mullis's opinions because of what they know about his lifestyle and character. Well, this I regard as astounding. This, I think, is, well, I can't seriously believe it in the first place. I mean, I want to know who these people are who are scientists who say we disregard a scientific opinion because it's being advanced by somebody whose lifestyle and character we disapprove of. I mean, I want to know what college they went to so I can avoid sending my children there. And I view this as a...
Well, The problem I'm having with your argument right now is when you lump together lifestyle. I agree with you, lifestyle is an inquiry that in this context is likely, very likely to be completely irrelevant.
Yes.
Whether or not somebody likes to surf or they went to Cal in the 60s and 70s and did the normal thing Cal students do,
Yes.
who cares? But when you talk about character, when you lump lifestyle and character together, then you've got a different inquiry. If you're talking about character in the scientific community, integrity of scientific research, integrity of the processes that they use, that's a different inquiry. So if you're lumping them together, you're creating problems for me.
All right. Well, I mean,
Because scientists do have reputations for the quality of their research. We do constantly hear about fraud in scientific publications and fabrication of results, that sort of thing. I mean, do you think that's a legitimate inquiry?
I think that surely would be a legitimate inquiry
All
if
right.
there was any record
You-
at all that it occurred. I mean, there's
Okay.
absolutely no showing
Right.
that
No,
that's
okay.
relevant to anybody.
But you agree that we should separate your comments about lifestyle and character? Because I'm talking about character in the scientific
Well,
community.
if by character we mean scientific integrity, that I see as relevant, potentially. Although, again, we want you to be judicious about how it was pursued. But if we mean character, for example, whether or not a person is kind to whether he's kind to his spouse, whether he beats his dog, whether he violates traffic laws, if that's what we mean by character, then I think it's irrelevant to the scientific merits. All right. So, I mean, if we define character in the limited way of scientific integrity, something that would go directly to veracity of the scientific opinions, then that would be a suitable area of inquiry.
Okay.
But, again, one would need to be very careful about...
I just want to make sure we're not lumping those two together.
All right, all right. Now, there's a second, beyond the irrelevance of this inquiry, there's a second reason to avoid it. And that is that allowing inquiry into such matters, the matters that Mr. Harmon proposes, is very intimidating to the defense witnesses, not just to Dr. Mullis, but to all of the witnesses that we might call. In this case, we're dealing with very complex scientific issues. It's not simple, and if we're going to get to the bottom of these issues, the scientists must know that they can come into court and tell what they know without having their personal lives scrutinized and their good names dragged through the mud. And I think the net effect of even the filing of this motion is to have a chilling effect on scientists who might potentially testify to an opinion that Mr. Harmon finds inconvenient. This motion, with its disparaging comments about Mullis, is particularly disturbing to us because we view it as part of a continuing course of conduct by Mr. Harmon designed to intimidate scientists who express views that he doesn't like in the courtroom, to silence them and prevent them or intimidate them from coming to court. There have been a number. Mr. Harmon is well known in the scientific community, and he's well known for exactly this sort of thing. There's been extensive discussion, both in scientific and legal publications, of Mr. Harmon's efforts to harass and intimidate those scientists whose testimony he dislikes or disagrees with. In one episode that was widely publicized, he threatened to have one scientist who was testifying against him thrown in jail for an expired driver's license. He has engaged in poison pen letter writing campaigns against scientists whose testimony he disapproves of, including attempting to interfere with the peer review process by sending disparaging information about scientists whose testimony he dislikes to journal editors. And we can document this, and we will, in fact, provide you in chambers copies of these documents. He has also circulated embarrassing personal information about scientists who he dislikes to their colleagues within the scientific community. I think a recent episode, the episode that occurred last fall in Sacramento, I think captures the tone and tenor of what goes on here. After the publication in Nature of an article by Eric Lander and Bruce Bedoli.
Mr. Thompson, before you go too much further down this particular road, the issue that I have to decide here is the scope of cross-examination of experts who testify here, and the character and practices of attorneys in other cases and on other issues doesn't strike me as being necessary for me to know to rule on this motion.
No, I disagree, Your Honor. I think in order to understand the meaning to our experts and why they consider this particular action by Mr. Harmon so intimidating, it's important to understand his reputation in the scientific community.
Perhaps I didn't convey the impression strong enough, but when I indicated to you that I observed this to be a preemptive strike and to be designed to sensitize the trial court as to issues that will arise, I thought I put in context how I view this particular motion.
Yeah.
Yes,
I
is that clear to you?
I understand what you're saying, Your Honor. On the other hand, what I want you to understand is
But see, we have the same thing. If you're criticizing one side for disparaging other people and conducting campaigns of libel and slander, then to come in and start doing the same sort of thing, then the argument loses its power, wouldn't you say?
Oh, certainly. But we'll document what
All right, so why don't we
we're
move
saying
on?
here.
Let's talk about the legal issues. I understand the social implications. I understand the practical implications.
Well, then understand what we're asking for. We're asking for an immediate ruling from you that this area of inquiry be off limits. Inquiry into people's personal habits, lifestyle, and so on be off limits.
You just told me that this is premature. Is it premature, or you want me to rule about it today?
Well, we want a ruling right now that these lifestyle inquiries are going to be off limits, and that any inquiry into personal background will be strictly limited to direct relevance. We'd also like a ruling from you that any future motions of this type be filed under seal and not released to the public. The very filing of this motion is an intimidating act, designed to intimidate and having had that effect. What Mr. Harmon is saying to the scientific community is, you know who I am, you know what I've done to other scientists, and if you come into this court, I have a dangerous new weapon at my command. Not only will I be able to disparage you in public, but I'll be able to inquire into your private, personal life and present the results of whatever inquiry I do in front of a national television audience. That is intimidating, Your Honor. We're talking about, these are not precipient witnesses who are subject to subpoena. These are scientists who, they don't have to come help us out by testifying. They don't have to do that. Speaking as a college professor myself, I can tell you, my colleagues find this very intimidating. They find it frightening. It's difficult to persuade them to come in and present their views if they're afraid that they'll be subject to this kind of attack. So we're asking you for a ruling now that will provide reassurance to our experts that they're not going to have their good names dragged through the mud by this kind of scrutiny. We want a ruling that holds that any inquiry along these lines will be strictly limited, and we want some protective measures to prevent future motions of this type from being distributed to the press. That's what we're asking.
All right. Thank you, Mr. Thompson. Mr. Harmon, any brief response?
Very brief, Your Honor. We sure flushed out a mouthful with just a legal brief addressing a very narrow issue. At times I wasn't sure whether Professor Thompson was responding to Mr. Clark's presentation or mine, and it's for the very simple proposition that they don't use that word reliability the way the cases use it. And when you cite a Kelly Fry published opinion talking about reliability, that's in the admissibility context. I am pleased that the defense would be happy to show an experiment that might suggest why our controls didn't work to show what adequate controls might be. it would be much more meaningful and it would be much more helpful to the trier of fact if they publicly, openly retested evidence in this case for the first time. I am happy that Dr. Mullis might be cross-examined on whether he's consumed LSD on the day of his testimony. Perhaps it would be in the best interest of the defense if they really are going to call him. I think that's really in doubt. Perhaps they get him in a detox center for a period of time so that when he testifies, I won't be able to ask him that.
It's more of the same.
Wait.
No,
Wait.
Thanks, Judge.
Wait. Mr. Harmon, I really don't need to hear that sort of thing.
Thank you, Your Honor. I appreciate that his opinions depend on the quality of his experiments, and I invite him publicly not to do an experiment, but to retest the ample remaining evidence in this case so he can address a scientific reality rather than some opinion that's based on partial information. I've already written to him and invited him to do that. I have not received a response. Thank you, Your Honor.
All right. All right, any other issues you want to address before we adjourn for the afternoon?
Your Honor, we have one further issue regarding stipulations. I have not talked to Mr. Harmon today about whether...
Excuse me, Mr. Blazier, let me just inquire of the court reporter. How are you doing? All right. Mr. Blazier.
Yes, Your Honor. There's an issue pertaining to 3 items that were provided to the defense back in October, which have been returned to the prosecution, save 1/2 of one swatch from each item. And Mr. Harmon has proposed a stipulation as to how that would be dealt with in front of the jury. We have proposed a counter stipulation. I have not heard from Mr. Harmon as to whether our proposal is acceptable. If it's acceptable, then the issue is resolved. If not, then I think we need to discuss it.
It's not, can we discuss it now?
Sure. Well, the issue is, as Your Honor may be aware, by virtue...
Do I get to go first since it's my proposal?
Well, Mr. Blazier's standing up, so let's just save time. I don't think I need to hear a lot on this.
No, it's really actually a fairly narrow issue. The stipulation that Mr. Harmon wants to present to the jury is to the effect that we possessed part of these items for a period of time and that they were consumed in testing by the defense. Now, the purpose of having any kind of stipulation at all is to allow the prosecution, which they're entitled to do, to account for the evidence that they might present to the jury. The evidence that they might present to the jury as to these 3 specific items is in the same condition it was when they gave it to us, with the exception that there's 1/2 of one swatch missing. We accept the fact that they are entitled to explain to the jury that there is 1/2 of one swatch missing because it was given to the defense. That solves any problem that they might have of accounting for that evidence in front of the jury. What we object to is that the jury be provided with any additional information about what we might or might not have done with those pieces of evidence. That does nothing to further their requirement to explain why this looks a little different than it was at some point in time earlier than that. Mr. Harmon proposes that the jury be told we used these up in testing, and the danger of this is set forth in his counter stipulation, which we clearly reject, where he wants to go into, well, you gave it to this doctor on this date and he didn't do anything, and then you gave it to this doctor on a second date and he did something to it, and he points out in his stipulation that the clear implication of this is that we were shopping around for experts, we couldn't find anybody that would give us results that we wanted, and the jury's going to be presented with that as a logical inference from that information. That's clearly, I think, improper on their part when the only problem that they have is accounting for the condition of the evidence as it's presented to the jury. Those are improper inferences. They aren't correct inferences. There are all sorts of other inferences that you can draw from the fact that we may have used something in testing, such as we want to impeach their witnesses with our results, that we got inconclusive results, we used unconventional testing. There are all sorts of things that could have been happened. If we choose to present an information, obviously it'll be provided to them and they'll have a right to deal with it. The only issue pertaining to this evidence is explaining to the jury that one half of one swatch is missing. We have no objection to them being told it's not there because it was given to us. There is nothing about that remaining swatch or remaining half swatch that needs to be explained to the jury. It's not as if we dusted it with fingerprint powder and it's got powder all over it and that's going to be apparent to the jury, in which case they would have to explain why it has fingerprint powder all over it. There's nothing unique about that one half swatch that requires any explanation other than the half they don't see was given to us. And we are prepared to stipulate to that. I think that's a reasonable stipulation. If the prosecution is unwilling to stipulate to that, then we would ask for an order from the court that that be the limit of what the jury is told about these items. Chain of custody is a non-issue in my view. We would not only be unethical, but we would be foolish if we raised arguments about the chain.
All right, back on the record in the Simpson matter. Defendant's again present with his second set of attorneys. People are ready with their third set of attorneys. All right, there was one other discovery issue, and just as to the other two issues, the court anticipates issuing a written ruling regarding the Kelly issue, regarding the scope of cross-examination issue. And we had a discovery issue also to take up. And I anticipate filing that Monday. Both, as to both.
And before we finish, we can have some limited presentations in chambers, in camera. There were some, at certain points in the argument, we made reference to things that we want to present to the court in that fashion.
Yes.
Should I proceed with the tape?
All right, let's go as to the discovery issues, however, first.
Your Honor, we have a number of concerns about discovery abuses with respect to a letter we sent you. The first issue has to do with the tape, which is the one that I think is most pressing because we believe it requires a hearing. The second issue has to do with the failure to provide certain laboratory pages, lab note pages, which we've been getting out of order really from the commencement of these proceedings, but we received a whole series of pages dealing with the chronology of events starting in June through July from Mr. Matheson in particular that we think we should have had a long time ago, and they impacted on things as distant as the split hearings and certainly related to other important matters. A significant issue that we would address for the court and is the late disclosure of these SETS printouts and the APIMS printouts, which we think is a discovery violation. There is a very significant issue that we've been given, what is it, Mr. Felicia, 200, how many pages? 283 pages with respect to shoe evidence, memorandums from the FBI of investigations that took place in August, interviews from all across the country, things that if we were to double track at this point in time with the limited resources available in the middle of trial is extremely difficult. We should have received all that material much earlier. There is an issue that will arise, I'm not sure it's so pressing for today, that a bindle of hair and fiber that was removed from the hat, the Bundy hat, in Albany by Dr. Lee, and was sent back and received at the SID laboratory, was subsequently lost. And Mr. Morton was unable to review that, and the prosecution has been unable to produce it. And we think that raises an Arizona versus Youngblood question, because that hat contained negroid hairs that were inconsistent with Mr. Simpson, which we think is potentially exculpatory evidence and would merit relief. With respect to the laboratory pages and the SETS documents, particularly the SETS documents, let me address that briefly. The problem there, Your Honor, is that we have been asking repeatedly from the very beginning of this case for all computerized records dealing with the chain of custody when these items were booked. From the very beginning, we got property reports initially, then we got with dates that were all plainly inconsistent with the facts. Then we got a computerized printout a few months ago, maybe 5 or 6 months ago, that just indicated when things were officially booked. It took a long time to figure out what that meant. Apparently, it represented the date that things entered the APIM system. I believe of the APIM system as opposed to the SETS system. As the court recalls, the SETS system is the computerized tracking system within SID. The APIM system is the computerized tracking system that I guess covers the Los Angeles Police Department. We finally received, through the court's good offices and the efforts of Mr. Hodgman and Mr. Yokelson, I think about 2 weeks ago, or a week ago really, a set of SETS papers for certain key items that we specified because we wanted to get what we could get. But when you look at those items, what it represents is every time a package is taken from one area of the laboratory to another, people have to hit their barcodes. And then it indicates whether something is in transit,
Well,
where it
Counsel,
went.
I'm familiar with what it is. What's
Okay.
the problem?
The problem is that in order to figure out what happened to each item of evidence, one has to go back through the voluminous testing records and try to figure out what was being tested or handled at a particular time, because what they're tracking are, they'll put like 7 or 8 bags or a whole bunch of envelopes into one big box. Then somebody in the serology lab may go in at various different occasions and test certain things or not. And in order to figure out who had access and where it went and how is an extraordinarily complicated task. This is not a system that is set up as many others are in a sensible fashion, where you can have one set of documents, computerized or otherwise, to figure out who had what item at what time, when it was taken out, when it was tested, etc. This is a nightmare to try to track through their evidence. Now, we should have had these documents a long time ago so we could figure out what we were dealing with and track these through. And it's late disclosure, we feel, and frankly, we haven't had any meaningful disclosure as far as the APIMS records are concerned. They just handed us these huge, incomprehensible sheets of documents. It seems to us merits an instruction to the jury that the prosecution has failed in its discovery obligations with respect to these chain of custody documents. They were not turned over in a timely fashion, and that the jury can consider that with respect to what judgments they can make about whether chain of custody was properly complied with. And we'll submit that request to you in writing, a formal request for an instruction. But the most pressing matter is this videotape, which I understand the court has viewed. We have been asking for this videotape for months, because a long time ago we saw on a television news clip a picture of somebody taking this videotape at Rockingham. In viewing this videotape, as I'm sure the court notes, there's a time on it that indicates when...
Date and time.
Date and time. We've been informed by the prosecutors, well, disregard that date and time, it's not correct. They failed to change the camera when they shifted over to new time period. But whether it's the daylight savings, whether it was the time that it purports to be on the camera, or whether it's discounted or moved ahead by an hour by virtue of daylight savings time, there are conflicts that we can see with respect to which people are seen at different locations in the documentation that we have in terms of when different searches were conducted. Perhaps most important of all, What does this videotape represent? We want to take testimony at a hearing from the people who made it as to what they were taping, who directed them to do the taping, what they thought they were taping. Were they taping the Rockingham residence and all the various different rooms as it was before any searches were conducted? What searches had been conducted before this tape was taken? Is this some kind of an inventory tape, or was this a tape that was taken to memorialize where various different pieces of evidence were? That's a question that we should have been able to explore at the suppression hearings in terms of the legality of the searches. This tape may suggest that searches were performed even before the search warrant issued. Or it goes to the nature in which the search was executed and the contentions about general search that were raised at that hearing. More importantly, for the upcoming collection witnesses, the location of various
Mr. Scheck,
items.
let me ask you this. Why do we need a hearing to do this? Why don't we just have the prosecution identify who the camera person was and make that person available for you to interview? I mean, why do I have to take up court time that I could otherwise use with the jury?
Well, we would like, Your Honor, well, first of all, I think that what we would want is that testimony under oath at this point, because we see contradictions. And we think serious issues. I'll give you a simple example. As I'm sure the court saw with great interest, at one point during the course of this videotape, the camera pans over the master bedroom and shows those straps that apparently were moved around at some point in time on the bed, and then just at the point where it's about to show the socks, a very critical piece of evidence in this case, and where they were at whatever time this tape was taken, the camera cuts all of a sudden and moves to a new position. We're very interested in why that happened. Also, the state of affairs in the bathroom and in other rooms, what was lying around, where it was, what knowledge these people have of that, that's something that we think should be taken under oath, that kind of testimony, so we can have that and use that on these issues.
Mr. Scheck, let me ask you this. Your letter to the court regarding this videotape was asking for sanctions, but you did not specify what sanctions you're seeking with regard to the late disclosure of the tape.
That's precisely the point. We don't know until we make inquiry of how this tape was created, who was leading around the person that was doing the tape, what instructions they had, what the circumstances of this were. We won't know what precisely the dimensions of the prejudice are, whether this tape helps us in certain areas as much as we think it might, whether or not it's something that the prosecution should be precluded from using parts or any of it. We don't really know. In order to figure out the dimensions of the prejudice here, we have to have a hearing, because it's very hard for us to figure out even the time that this tape was taken, much less the impact it has on search questions and also on the upcoming testimony of the witnesses who sees things at Rockingham. That's our problem, and we want that under oath. I mean, I'd like to accommodate the court in terms of the jury time. That's why I was perhaps inappropriately pressing the court to consider this issue yesterday. But we're very serious about this. We think this is a very serious discovery violation. I can point out to the court that there's panning of that garage area and the door, objects near that door. That's something that the defense should have known when it was cross-examining Detective Lang about pictures of that. It's something that the defense should have been able to see in cross-examining Detective Van Adder and others in the trial, Mr. Kalin, about that whole general area. What was the state of objects in that Rockingham address at a particular time is something that we were entitled to know at the suppression hearings and before this trial started. And we asked for this tape numerous times, and it was suppressed. The circumstances of why it wasn't turned over, I think, are also extremely relevant in terms of what sanctions the court might want to impose, and I think we need to have testimony as far as that's concerned. So
So you're asking for a hearing at this point?
That's exactly right.
All right. Ms. Lewis, is this your issue?
Your Honor, actually, Mr. Goldberg is going to address the court first to set forth the law and talk about the other documentary items. I'm going to deal with the videotape, so if you don't mind, we can take it in reverse order.
All right, let's do the videotape first.
Oh, you do want to take the videotape first?
Yeah.
All right. Your Honor, I had a conversation with Detective Looper of the Los Angeles Police Department yesterday, who was the detective responsible for the execution of the search warrant on June 13th at the defendant's residence at Rockingham. I believe Detectives Van Adder and Lang were downtown with Mr. Simpson during that period of time, and that's why he was responsible for it. That videotape, as Your Honor has seen, I guess several times now, depicts the premises in and about the house very briefly, and all of the valuable items, including the many trophies and plaques and awards and so forth within the house, as well as the furniture, paintings, other items of value, and was taken as part of LAPD's ongoing policy to videotape locations where search warrants are executed. It's a policy that came into implementation, I'm informed, because of the 39th and Dalton lawsuits, which happened a few years ago, several years ago now. So that the policy of the police department is to take a videotape for their own civil liability, administrative purposes, to make sure that they don't have claims against them later that they've stolen property or they've trashed premises. That was the whole reason why this particular tape was taken. The tape shows the same locations that are shown in photographs. The defense has had photographs of the interior of Rockingham for months and months. Those photographs show almost the identical things that are shown on the videotape, except the emphasis with the videotape is on the value of various items, because it was taken with that purpose in mind.
So are you indicating to the court that this was taken by some LAPD photographer or videographer?
Yes, it was taken by, if the court recalls, there's a gentleman in a suit in there who I didn't recognize. He's apparently a supervisor from SID who was there, who came out with a, whatever you call somebody like that now, videographer, specifically for the purpose of capturing those things because of potential civil liability, which the Los Angeles Police Department occasionally experiences when it gets sued over matters having to do with the execution of search warrants. So that was an administrative tape taken for that reason, and it was a different, I'll just finish this sentence, I see you're about to inquire, but it was taken by a different person than the person who went through and did the photos. And it's also evident that this was an administratively taken videotape, itself authenticating in that respect because of importance. It does not show the blood in the foyer, the blood in the driveway, the pathway.
There are two, it does look down at what appears to me to be two of the blood spots in the foyer.
Okay, I missed
Two of
that.
the
I'm
blood
sorry if
spots,
it
right?
does.
And pauses it.
Yeah.
Well, I fast forward and rewound a little bit, so I didn't see that.
I watched it 4 times very carefully.
Well, I certainly trust Your Honor's perception then. But the point is that it did not go down the pathway. It was not meant to and did not record the scene as a crime scene. It did not record the most pertinent aspects of it.
Forgive me for interrupting you, Ms. Lewis, but the issue that I'm interested in is who took it, and why wasn't it turned over earlier than this week?
It was taken at Detective Looper's direction, as I mentioned. It was given to him the following day. He threw it in a drawer. Knowing that it was going to be for administrative purposes, it didn't occur to him to seek to make it part of the discovery type of materials in the case.
All right, let me ask you one other question. During some of the news coverage of the search at the Rockingham residence, long before I had any involvement in this case, I did see some news coverage in what I now recognize as the pool area, the wrought iron table out by the pool area, of a person that I recognized as a district attorney photographer who was carrying a full-size VHS camcorder.
The DA photographer did videotape the June 28th search.
Okay, perhaps that's what I saw.
I believe so, because I know this was an SID personnel on the 13th. And I believe the defenses had discovery on that June 28th
All right.
videotape. So what we're talking about here is something that was after Detective Looper threw it in his drawer. At some point after that, LAPD made available to the RHD an additional room to be set aside for this case alone. I was just going to give the court what happened to the tape after he threw it in his drawer.
Well, I'm just, Ms. Lewis, do you agree that perhaps the defense is entitled then to inquire of both Detective Looper and the videographer as to the facts and circumstances regarding both the creation of the tape and an explanation as to where it's been for the last 7 months?
I think that is a reasonable thing for them to do. We'll make Detective Looper available, assuming he's working tomorrow morning. It's Friday, I'm not sure, but we'll make him available tomorrow morning, and the same with the other person. They can speak to him. They're very forthright individuals. There's no reason to tie up this court's valuable time with a sequestered jury to have a hearing, some kind of a formal hearing on it. It's really not necessary, Your Honor. And the defense can easily satisfy their questions and their questioning with Detective Looper. And in fact, there's one aspect that Mr. Scheck didn't mention, but what we noticed about the videotape was a glove that shows up in the videotape more distinctly than it does in the photographs, and there's an explanation for that. They've not inquired about it, so I won't tell them. But Detective Looper certainly can tell them that, and I don't want to take up the court's time. I don't mean to be mysterious, but I've satisfied myself from looking at the videotape by asking Detective Looper certain questions about certain things I saw in there, and I think the defense can satisfy themselves more easily so, probably, by doing it informally with the detective and with the other person than in a formal court hearing.
All right. Mr. Scheck?
First of all, Your Honor, were we allowed to respond to the other items?
Yes, you will. Let me just finish the videotape first, and let's get that out of the way. Mr. Scheck, the only thing I'm interested in from you at this point is why do you feel it's necessary to have a hearing under oath at this point if the prosecution is willing to make these people available to you first to interview? Because my suggestion to you is that I'm going to direct the prosecution to make them available to you tomorrow if they're on duty and available. And after taking statements from them, if you feel a further hearing is necessary with testimony under oath, I'll accommodate you then. But I'd like to do it the easy way first rather than having to, I don't want to necessarily use up my court time.
I think that the only problem is that we can't be at two places at the same time. And I suspect that the next witness is Mr. Fung. And we would like to know what these people are going to say about the circumstances of the tape. And if we had even learned about it any time earlier, we could have taken up the court's suggestion. The problem is that this is directly relevant to the testimony we're about to hear.
All right, well, let's do this then.
I would note one other thing, Joe.
Sure.
I'm informed that employee at Mr. Simpson's residence testified at the 1538.5 hearing that she saw somebody there doing a videotape. So this was another reason that we've always maintained that there was such a tape, and I think they're on notice of it.
All right. Let's do this then. Let's order Detective Looper and the videographer here tomorrow morning at 8:30.
There's one other person too, Your Honor.
The most, I think, relevant person is the fellow in that interesting gray suit from SID.
With the badge hanging out of the...
Yes.
Okay.
Who is?
You noticed that too.
I believe he's an SID supervisor. If these people are working tomorrow, we'll certainly
Okay.
have him.
How about if we have everybody here, those three persons involved here tomorrow morning at 8:30? Counsel be here at 8:30. We'll just have an informal interview. If you feel after inquiring of them that a formal hearing is necessary, I'll entertain it at that time. But I suspect, Mr. Goldberg, are you going to be handling the direct examination of Mr. Fung?
Yes, Your Honor.
And just out of curiosity, chronologically, where do you intend on starting your evidence collection saga?
It starts at Rockingham.
I was afraid of that. Okay. Well, I guess we need to resolve this issue first. All right, tomorrow morning at 8:30 with the three persons available.
Yes,
All right,
Your Honor.
and Ms. Lewis, I give you leave to use the court phone right now, so let's make sure we get these people.
I'll do that in a minute.
All right, thank you, counsel. All right, Mr. Goldberg, as to the APIMS, sets, et cetera.
Your Honor, before getting directly into the facts regarding this APIMS and sets issue and also the other issue raised by counsel, which relates to these new L numbers of the laboratory reports, I just wanted to discuss general principles of California discovery law as we understand them now in a post-Proposition 115 environment, because I think that they will be helpful to the court in resolving not only these issues, but perhaps the issue about the videotape, as well as other discovery issues that are going to arise throughout these proceedings based upon the history of things that have gone on to date. First of all, the people's discovery obligation now, as I understand it, is limited to essentially two sources. Number one is the Constitution of the United States. We have to provide exculpatory materials, so-called Brady materials. And the second source is the Penal Code, 1054 of the California Penal Code. And therefore, in any discovery issue that is before a judge now in a post-Proposition 115 environment, there is essentially a two-stage analysis that the court must go through. One is to look at the issue of whether or not it is exculpatory within the meaning of Brady, and the second is then to go systematically through the Penal Code and mechanically apply what has been set down by the people of the state of California through the initiative process as the law of the state. Now, I'd like to address first this issue of what is exculpatory evidence and cite a couple cases to the court, which Your Honor is probably already familiar with in counsel. Don't worry, it's not the entire notebook here, but well, we'll do that later on this afternoon. But they do set forth a definition of exculpatory that I don't think we're really that familiar with here in California, because prior to Proposition 115, we basically did follow rules that were judicially created. And those discovery rules were essentially that we just had to turn over everything that we had in our case file unless it was somehow privileged. So the general rule is you give it over unless there's some specific reason why it is privileged. But that is not what the United States Constitution requires. And one case that discusses this is California versus Trombetta, the United States Supreme Court case that the court is familiar with at 104 Supreme Court Reporter, and I'm looking at page 2534. The court is probably familiar with this in the context of what we call in our state hitch motions, where a piece of evidence has been intentionally or negligently destroyed. But they also discuss discovery obligations, and they say that the definition of materiality for the purposes of determining what's discoverable is the same in the context of what we call a hitch motion as it is in the context of a Brady material. And what they said there is that whatever the duty the Constitution imposes on the states to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. And then they have a footnote, and in a footnote 8, they say, in our prosecutorial disclosure cases, we have imposed a similar requirement of materiality. And we have rejected the notion that a prosecutor has a constitutional duty to routinely deliver his entire file to the defense counsel. We know of no constitutional requirement that the prosecution make a complete and detailed accounting to the defense of all police investigatory work on a case. So the Constitution does not require us to turn everything over. It does not require us to empty out our files as was done in a pre-Proposition 115 environment. So we know that materiality does not mean you empty out your case file and give everything that's not privileged to the defense. In order to decide what it does mean, we have to continue on with some of the cases. And next, I call to the court's attention another fairly well-known United States Supreme Court case, U.S. versus Augers, at 96 Supreme Court Reporter 2392, and I'm looking at page 2400. There, the United States Supreme Court says, the Court of Appeals appears to have assumed that the prosecutor has a constitutional obligation to disclose any information that might affect the jury's verdict. That statement of a constitutional standard of materiality approaches the sporting theory of justice, which the court expressly rejected in Brady. For a jury's appraisal of a case might be affected by an improper or trivial consideration, as well as by evidence giving rise to legitimate doubt on the issue of guilt.
One of my favorite judicial passages.
It's one of my favorite too now, Your Honor. If everything that might influence a jury must be disclosed, the only way a prosecutor could discharge his constitutional duty would be to allow complete discovery of his files as a matter of routine practice. Whether or not procedural rules authorizing such broad discovery might be desirable, the Constitution surely does not demand that much. They went on the same page further on in another paragraph. The mere possibility that an item of undisclosed information might have helped the defense or might have affected the outcome of a trial does not establish materiality in the constitutional sense. So what we are essentially told in this case is we're talking about substantial evidence that might cause a reasonable, objective fact finder to find a reasonable doubt. And that is the way it is also defined in California case law, where the court is probably familiar with the phrase substantial material evidence as being the sort of slogan that we use to describe what's discoverable. And in People v. Gonzalez at 179 Cal. 3rd 566, they talk about this standard of substantial material evidence in terms of evidence that's expected to play a significant role in the defense. And they say in that case, citing Trombetta puts it this way: whatever duty the Constitution imposes on the states to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense to meet the standard of constitutional materiality. And then they continue on further down in that same paragraph. In our prosecutorial disclosure cases, we have imposed a similar requirement of materiality and have rejected the notion that the prosecutor has a constitutional duty to routinely deliver his entire file over to defense counsel. So we basically know, based upon the federal and California cases, that when we're talking about materiality, we're talking about substantial material evidence of the kind that's expected to play a significant role in the defendant's defense, such that it would cause a reasonable or might cause a reasonable finder of fact, in other words, an objective finder of fact, to find a reasonable doubt. Now, as I understand it, the defense in this case is fairly straightforward in some ways. As I understand it, the defense is that Detective Furman planted the glove and then perhaps broke into the vehicle, the Bronco, and wiped the vehicle with the glove. Now, if that is the defense, does the defense believe that it's reasonably possible that he took the glove from Bundy, drove it to Parker Center, booked it into evidence so that it went through APIMS, then drove back out to the location at Rockingham to plant it, and then wipe it throughout the Bronco, and that if they only had the APIMS material, they're going to find some evidence of this? It is very difficult when you apply the standard of constitutional materiality to figure out how they can make a legitimate argument that this APIMS and SETS material falls within that definition. In order for the court to understand this, I'd just like to give you a little bit of background in terms of what these materials are.
Well, before you do that, Mr. Goldberg, isn't it correct, though, that the defense has already been given a set of each of these materials?
That's true.
So isn't the argument sort of moot? They've got it?
No,
the question is how was it interpreted, or whether or not there's any other way to...
They're asking us to reformat it. And see, this is one of the problems that we get into, when, in my view, when we give them things that we are not required to do under the Constitution, that we're not required to do under the Penal Code. And I could turn to the Penal Code and also show how it doesn't come within any of the provisions of 1054. The problem that we get into is we think that we're being nice guys by jumping through all these hoops that they've set up for us. And every time that we've complied with these hoops, they always have a new hoop that they want us to go through. We thought, okay, we won't argue about the APIMs, we won't litigate it, we won't ask the court not to argue it. It doesn't come within the Constitution, it doesn't come within 1054. We'll be nice guys and we'll give it to them. We did the same thing with the sets material. We decided that what we were going to do on the APIMS material was, rather than trying to decide what they might want and what they might not want, is just give them everything. So it is incredibly voluminous. And it includes the kind of computer codes, and I don't know the correct terminology for it, the encrypted type stuff that's used in a computer to generate the thing that you can read. It's in English. Maybe Your Honor knows what I'm talking about, because I'm just not familiar with the correct computer terminology.
No, if you recall, I've seen the printout that we're talking about.
Yeah, that's right.
Okay.
So they have everything. What they're saying is that the materials that they have are sorted out chronologically. They're not sorted out by item number.
All right,
So-
Mr. Goldman, let me just jump ahead of you for a moment. Your argument is going to be is that your only obligation, even assuming that these are material, meet the test of materiality, your only obligation is to turn it over, not to interpret it for them, not to make it easier for them to understand, that your only obligation is to turn it over. Whether or not they understand it is up to them. Whether or not it makes any intelligible sense to anybody is up to them. It's not your obligation to sort it, explain it, and help them digest it. That's your argument, correct?
That's essentially it, Your Honor. Yes, that's correct.
All right. See, it's easy as a former prosecutor that I can sort of guess that that's where you're going.
Okay. Yes, that was where I was going, Your Honor.
I've heard that argument myself. All right.
But in this case, it happens to be correct.
I don't mean to interrupt you, but sensing where you're going,
Okay.
I thought I'd sort of jump ahead
No,
a few
I
steps.
appreciate that, Your Honor.
Okay.
And I don't know if the court wants me to continue, if you feel it would be helpful as to what exactly APIMs and sets are, because I think that it's been somewhat overbilled. They're not chain of custody type systems. What they do is they're something that would be used by someone who wanted to know where a piece of evidence was. So, for instance, if I were looking for the socks, item 13, and I had no idea where it was, where to start, I could, hopefully in APIMS, find that it had been, if it were sent out of LAPD and no longer in their custody, that it was in the court's custody. I could find that. That's the kind of information I could get through APIMS. But that would be it. I could also find out when it went into LAPD's custody, so it's sort of an in-out type thing.
All right, and for the court reporter's benefit, why don't you give us what the acronyms APIMS and SETS stands for?
Yeah, I wish I knew, Your Honor. You know, I've been practicing law for almost 10 years as prosecutor, and I had never heard of these systems until this case. I don't know whether maybe Your Honor had. I know that you have more experience in the judicial system than I. I've taken an informal poll and asked other prosecutors, and I don't think they've ever heard of it either, and I'd scarcely doubt that any defense attorneys prior to this case have heard of it, and that's why I have a lot of trouble with the idea that it is exculpatory material that would violate the defendant's due process rights if it wasn't turned over. I mean, everyone else has seemed to be able to litigate their cases and defend their clients without the benefit of this kind of material, except the defendant, Mr. Simpson.
Well, let me tell you what I foresee, though. I foresee cross-examination as to the chain of custody and integrity of the evidence during the testing process, and then asking the persons involved, primarily the criminalists from LAPD SID, to explain the chain of custody based upon these documents, which are probably unintelligible to the average human being.
Well, you know, I think the APIMS document is also unintelligible to the criminalists, because it isn't the system that they use in-house. And when I was trying to find out about the SET system, since, as I said, Your Honor, I really had never heard of it or even knew that such a system existed. So when I was trying to learn a little bit about it and how it worked, I learned that many of the criminalists don't know exactly how SETS works either. They know what they do to it, and how they barcode things in, but they don't have a lot of understanding in terms of what happens to the information once it's in the computer. It's the kind of information that it really only serves one purpose, and that's if you're a criminalist and you want to know where within the laboratory I can find this box at any given time, because remember, it goes to boxes, not item numbers. You can use the SET system to do that. So I don't know how they could cross-examine them really effectively about something that they have very little knowledge about. What they need to do is the same thing that we did in this case.
But I suspect their whole goal is just to show that there's no coherent inventory system.
Well, there is. And the coherent in
No, I'm
inventory.
just saying that that's going
right.
to be their goal. Whether or not that's true or not is for them to decide.
Yeah. Well, what the defense has to do is what anyone would have to have done before the advent of computers, and evidently this is reasonably new. I don't think that it's been around for 10 years or
Do you
anything
feel
like
comfortable,
that.
though, that I understand the prosecution position as to, now that you've turned over these computer printouts, that that's the end of your obligation?
Okay, thank you, Your Honor.
Okay.
I'll move on to the L numbers, if I might.
Sure.
This seems to be typical of many of the defense allegations of prosecutorial non-disclosures of information, in the sense that they don't give the court any specifics. They just say, we got a bunch of L numbers, new L numbers, and there's a discovery violation we want to sanction, without specifying what, if anything, is new, what's startling about these things, which one of these, if any, comes within the definition that we've just talked about in terms of exculpatory evidence or within the California Penal Code. Because again, we're turning over stuff that we really, in my view, in many instances, don't have any obligation to turn over. We've kind of taken the tact that is not required by the Constitution of emptying out our case files, and now they want to penalize us for doing this. What happened here, Your Honor, was with respect to a large number of these L numbers, Greg Matheson, who is one of the supervisors at the Scientific Investigations Division and also a witness in this case, was going through the materials that we've already turned over and recognized, as we had earlier on, that when L numbers were assigned initially, way back when, they were only assigned to the face page of a particular document, so that you might have a 12-page document with only the face page having L115, for example. And 116 would be a document that was 16 pages later, again being a face page. So in the interest of completeness and having some way of being able to prove, if we needed to, that the defense had a particular document, since they frequently come up to us and say, we never got this, and then we can go back to our records and prove that they did. What he did is he renumbered and reissued many of these pages that the defense already had. That reissuing was from page L579 to 715. So as to those items of these alleged 300-odd pages that the defense says or claims that they have that are new or previously unaccounted for, many of those I would assume fall into that category. As to the remainder of the items, according to what I have been able to determine, they are all relatively recent materials. And many of those materials dealt with records that were compiled itemizing the numbers before we sent them out to Albany for the defense inspection, itemizing them after they came back. There were notations as to the laboratory visit that occurred on Saturday. I believe that was the 3rd or the 4th of this month. There were many materials, many of these materials not falling with any of the provisions of the discovery law, which, as the court is familiar based upon our last discussions and the discussion of particularly Hines versus Superior Court, may include notes, but it would include notes of laboratory analysis, comparisons, observations, testing, and the like. And many of these things were chronological references to events that took place that have nothing to do with testing or analysis of evidence and the kinds of things that come within California case law that requires disclosure of certain notes under Proposition 115. So I think that the burden is really on the party that's making the allegation of discovery abuse to go through, to itemize the specific page numbers that they claim that they didn't have, and to try to articulate to the court what these are, why they're important, why there's been a discovery violation, so that the court has some basis upon which to make a decision on that issue. I just like briefly, I don't think the defense is asking for any relief on this right now, to mention the issue of the bindle of hair and fiber. I did not know anything about that issue until it was raised here, but what I can tell the court is that the procedure that the Los Angeles Police Department used is they photographed the evidence before it went out, and then photographed it after it came back. Of course, that's produced an enormous number of photographs, hundreds and hundreds of photographs, which the defense has. But that should be able to dispose of this kind of allegation. I'm not sure that the defense is asking for any form of relief on this at this time. Maybe they're just announcing it for whatever press value they feel it has. But I do believe that the court should summarily deny the defense claims of discovery abuses regarding the APIMs and set materials and also the new L numbers.
All right, what about the comment regarding the 283 pages of shoe evidence and reports from the FBI?
That was something that Ms. Lewis also looked into.
So I'll stand up and talk about that with the court's permission.
All right.
Your Honor, these materials are almost exclusively repetitive copies of a form letter, essentially, that was sent from the FBI, I believe, to various shoe manufacturers around the country. So it's correspondence, basically, and it's other types of memos and correspondence from this expert who we will be calling. But it's correspondence. It's not materials which are discoverable, as Mr. Goldberg has just talked about in terms of what materials are discoverable. These were things...
Mr. Bodziak's
yes.
materials?
Yes.
All right.
And these were, he basically cleaned out his files. Mr. Goldberg alluded to us cleaning out case files. It's a similar analogy. He, after finally completing his reports, and I don't want to represent they're totally complete, because they may not be. But in terms of completing the reports that have been done to date and the analyses that have been done to date, those were the priority. That's what he sought to finish on and did. He got those out. And then he went far beyond what the defense even asked for in their recent letter which requested materials from Mr. Bodziak or Agent Bodziak. And that is correspondence and virtually everything he had in his files. So again, we turned over, as is my position as well, frankly, that we turned over materials which were not required under the discovery laws. And we have been especially forthright in this case from the beginning, and that was a decision made from the get-go to do that. But again, it's a similar situation where these are letters and correspondence and things that are not discoverable under the discovery laws that we turned over anyway. And so certainly we should not be sanctioned for turning over what we did not have to turn over. The defense should be grateful that they have received this information and early, before the expert testified. Your Honor, I want to mention that I did talk to Detective Looper. He'll be here at 8:30 in the morning. He's spoken with Mr. Ford, the one who actually did the videotape. He'll be here. We've not yet reached the supervisor because he's out doing something work-wise, so we should certainly be able to reach him as well. And it also occurred to me, back to the videotape for a moment, the blood on the carpeting would also be for liability purposes. That would be the reason why they would
Also the blood.
videotape that.
Blood on the foyer.
On the foyer, whatever. It would be for liability purposes so that they couldn't later claim that the whatever material it is in the foyer or paint, I forget where this blood is, frankly, but so that it wouldn't have been something that the LAPD damaged.
I think the argument is going to be, though, that what time, when, who was there when it was collected, and if it's still there at 2:30 in the afternoon or 3:30, depending on what time.
I have it through hearsay, because I didn't ask Detective Looper myself. I should have, that this was all done after the search warrant was executed, but we'll know that in the morning with certainty.
Okay. All right. Mr. Scheck, you want to tell me a little bit more about the bindle, the lost bindle?
Yeah. Mr. Hodgman and Mr. Yockelson have been dealing with it. My understanding is that they actually have photographed the return of the bindle. So it was back here, and they, at this point in time, have lost it. So I think that's a pretty simple matter. With respect to the L notes, I think that Mr. Goldman's argument admits too much. First of all, the L notes were given to us out of order in the first place. In other words, we would get a crime scene checklist from Mr. Fung, and you'd find one page is L33 and the other one is 576. And that's the way we were receiving things in this case, and not great copies either. It is annoying because I wish I had a nickel for every time Ms. Clark got up and said everything was being turned over. But let's move on to the legal issue. United States versus Agers was overruled. United States versus Bagley is the law with respect to materiality. And the difference between Bagley and Agers on the issue of materiality is significant, because in Bagley, the court points out that materiality should be determined from the point of view of what the defense wants to do with something, some suppressed evidence, what its theory of the case is, what it needed at a particular time. It's no secret that the chain of custody documents that we are specifically asking for all along has been an essential element of the defense, as the court from its comments revealed. There is no excuse under the United States Constitution to continually refrain from turning over material that tracks the chain of custody of these documents and is relevant. It doesn't strike me as a particularly persuasive argument that the criminalists at SID have no idea how the system works when it's designed to assist them in tracking documents and creating a chain of custody. That argument, again, admits more than I think Mr. Goldberg intended. And it's for that very reason that these documents were in chaos, to turn this over so late so that it becomes a nightmare for the defense to try to figure out which item was tested at what particular point in time and who had access to it, is sandbagging. We've been asking for this for a long time.
All right, Mr. Scheck, let me bring some closure to our discussion then. First of all, as to the laboratory notes, the L notes that you're discussing, the fact that these were turned over to you at this point recently, and this comment also goes to the FBI notes regarding the shoes. What I think you need to do is present to me something that indicates that these items are material, that they should have been turned over, and that there's some prejudice to you from having not gotten them recently, because if they are as represented, they sound relatively innocuous.
No.
All right.
I mean, I tried to be specific. I'll tell you, I'll ask Mr. Blazer to address it. I'll put this in writing, but just so you know, I only addressed Mr. Matheson's chronology. Mr. Matheson testified as a witness in the split hearing. He, as you recall, had great difficulty remembering exactly what the discussions were on, when evidence was going to be sent out for DNA testing, and who did what and when.
Oh, I understand,
Well,
counsel.
he created a chronology. He was doing a step-by-step chronology that wasn't turned over when he testified and wasn't turned over subsequently. It was only turned over last week. Plainly material, and I'll lay that out for you.
All
Mr.
right.
Blazer can address, if you want now or if you want it in writing, the issue of the shoes.
All right, both as to the lab pages and as to the shoes, I want that in writing. As to the lost bindle, let's have Mr. Hodgman look into that.
Yes, I've already started that, Your Honor.
All right. As to the videotape, we will start tomorrow morning at 8:30. I expect all interested parties to be here at 8:30. As to the APIMs and sets matters, I think I agree with Mr. Goldberg's position that the obligation of the prosecution is to make whatever is available, which they have done, and they have no further obligation to interpret or simplify.
Our position is when they made it available. Too late. That's the point.
Well, now you raise that issue.
No, I said that at the beginning. The point is not, the APIMS records are unintelligible. Our point from the beginning is this. We have been asking from the beginning of this case for the chain of custody records, the computerized chain of custody
And they've
records.
given it to you. And if
Well, they
it's
gave it to us.
Mr. Scheck, if it's unintelligible, That sounds like a terrific thing to me, from your point of view, to cross-examine on.
No. The problem, particularly with the SETS records, is that they refrained from giving it to us until I think about 3 weeks ago. Now, that is wrong. That is a violation of their discovery obligations. It is plainly relevant to our defense.
Mr. Scheck, your arguments to me have never mentioned that you're complaining about it, that you just got it. You're complaining about what it says and how you interpret it. This
No.
is the first time you're telling me.
No,
Yes.
Your Honor.
Yes.
Well, then I did not articulate it to you clearly enough. Let me be clear. My argument was, it was turned over late, and the SETS records, in conjunction with the other laboratory materials, require exhaustive cross-referencing. I think that's what I said. And by getting it late, we have been prejudiced, because we still are trying to do that, and we shouldn't have that burden at this point in time. We should have had it months ago, so we could further our investigation. That's the problem. To the court says, finally, we continue to be prejudiced by the prosecution's failure to produce in a timely fashion computerized records from SID and LAPD. That's the problem. Of course, it's an aggravating factor that they turned them over in the APIMS records.
So what remedy do you want?
I want an instruction. I want an instruction to the jury that the prosecution violated its discovery obligations by failing to turn over these chain of custody records in a timely fashion, and that they can consider that with respect to the credibility of the prosecution's witnesses on the issue of chain of custody.
All right, we'll stand in recess, 8:30.
One thing we need, very briefly, we still need to know the list of witnesses for the next 3 days, as part of the court's initial order, especially now because there are different lawyers who are handling different witnesses and people are kind of...
All right, that's something that's supposed to be exchanged informally between the lawyers. All right.
Is the court's ruling on this, the APIMS and the consents material still stand?
Yes.
Can we just ask the court's question about scheduling issues?
All right.
In terms of tomorrow, I think there were still issues that they wanted to raise. The defense said about the boards that we intended to use. I wanted to know when that was going to be brought up.
Bring them here at 8:30.
Okay, so the court wants to do that before the witness is called.
Right. All right. That's the normal procedure.
That's why I would make sure.
All right.
Since
All right.
you would like an opportunity to see the tape, may he stay here and use your equipment to view it?
We don't have it hooked up to the monitor right now. I excuse Ms. Fitzpatrick. She'll be here tomorrow morning. We'll show it to Mr. Simpson tomorrow morning at 8:30. 8:30 session is not open to the public. This is just informal discussions. We'll make that available. All right. Thank you, counsel. Where's Mr. Dart?